paragraph 31, which
Paragraph 31.
Yes, and simply to ask her, and I think she has done that, to confirm that that Annexure L was not part of SB 10.
Let me correct that, Chairperson. It was not attached to SB 10 in my affidavit, but it was certainly part of the memorandum that was submitted to the minister when it was submitted. But as I've been painfully trying to explain, we did not add all the annexures when we did my affidavit, and they have been now supplied to council, to Advocate Chauke's team.
Advocate Batohi, can I ask you, on your main defense on this issue, which is that this was a draft letter that you prepared for the president to sign when suspending Advocate Chauke, and you did not expect that these would be the terms of reference. Now, it is a bit of a puzzling expectation on your part. Why did you not expect them to be part of the terms of reference when you've given them to the president?
My understanding is that we submitted a draft, but I could be mistaken about that. But this was a letter to the president, and I didn't know what in fact, it was a draft. The president is at liberty to change that letter as he deems fit. We did not expect that this will find its way into the terms of reference. It was explaining to the president, in summary, what issues we had with Advocate Chauke's conduct.
Yes, there was another document, but we have not found the source of it. If you go to page 177 of file 3.
I'm sorry. This draft letter, as you have just mentioned, sought to convey to the president what issues you had with Advocate Chauke. As you have just mentioned, I just want to check.
Can we look at the draft letter again,
No.
Chairperson?
I'm referring to your answer that you have just given now.
Yes, I answered it, but when I realize it's being scrutinized to the level it is, I'd like to look at the letter.
No, Council. I'm asking you. You responded just maybe a minute ago that the draft letter sought to convey to the president what issues you had with Advocate Chauke. That was your response.
Chairperson.
Because I want to ask you a question on that statement.
Well, I would like to look at the letter first.
No. Did you answer to Council his last question when I interrupted him, that you answered your draft letter to the president was to convey the issues you had with Advocate Chauke?
Chairperson, that was loosely put. That is why I'm asking that I refer to the letter. There may have been other things there that I added, and I think in fairness, I should be allowed to look at the letter and then say exactly. I loosely put it. I didn't refer to it because we've been through some of it and we've compared it with the terms of reference, and it relates certainly to some of the conduct that we had an issue with, but there are other things in the letter as well.
No, I'm not talking about the contents of the letter. I'm asking you a question based on your answer to Advocate Ngcukaitobi, that your draft to the president was to convey the issues that you had with Advocate Chauke. That was your answer, correct?
Chairperson, we sent a whole bundle of documents to the president.
No, Council. And I'm going to ask you again for the last time. When you responded to Advocate Ngcukaitobi a short while ago, you said your draft letter to the president sought to convey to him the issues that you had with Advocate Chauke, the words to convey the issues you had with Advocate Chauke. Is that what you said?
That's what I said, loosely.
Yes, thank you.
Yes. In fact, on this topic, the suspension letter of Advocate Chauke is identical to the draft that you prepared. I don't need to go through it, but we
That's
can
fine.
accept that.
Sure.
Yes. Now, I wanted to just come back to trying to understand what is the substance of your answer. There is a document headed the Presidency Draft Terms of Reference at page 177 of file 3.
What page is that?
177, Madam Chair.
177.
Yes. Now,
And what is the question with regard to that?
yes, thank you. If you could go to page 179. What this document does is to identify the issues to be decided.
What is this? I'm sorry.
Yes.
For the purpose of the record, what is this document
Well,
at page 177?
I'm very happy, Madam Chair, you've asked that question because it's one of the documents we received from Advocate Lekgetho. And I was going to ask the witness to explain what is the status of this document.
At 177.
At 177, yes.
Yes, thank you.
Yes. Advocate Batohi, if we could just go to 179. This document purports to identify the issues to be determined by the inquiry. At Roman figure 1 and Roman figure 2 in broad and generic terms, but does not identify any terms of reference in the same detailed sense that the gazetted terms of reference do. Now, who prepared this document at page 177?
So this is the draft terms of reference that I was referring to earlier, Chairperson. It was prepared by my office.
Was this a first draft, a final draft?
I can't recall. I assume it would have been the final draft.
And what happened to it? You gave it to the minister?
Well, I thought it would have been sent to the minister because that's why we drafted it. But I'm not sure.
Yes. In any event, the point I'm really trying to understand here is it's only at page 179 where there is an identification of the issues to be decided. But there are no actual terms of reference in that document at all.
The heading of the document is draft terms of reference.
Of course.
And in fact, there's nothing wrong with having broad terms of reference.
Now, what I'm asking you is there are no terms of reference in the document. There is an identification of the issues to be decided at page 179.
This is a draft terms of reference document. We can quibble about semantics, but this is the draft terms of reference. And at page 179, as you say, the issues are broadly defined.
Yes. The only document that specifies the complaints against Mr. Chauke to the level of the terms of reference is what we were looking at page 181.
That's the letter to the president and not
Indeed.
the draft terms of reference. That
Indeed,
draft.
yes.
That's correct.
And that's what ultimately makes it as terms of reference by the president.
That was
Page 181.
That's the president's decision.
Yes. Thank you. Now, in relation to that final document and your own draft, You've never identified the issue of Mr. Chauke acting in excess of his authority as part and parcel of that letter at page 181.
Chairperson, I'll have to look at this carefully. Chairperson, the terms of reference have got to be drafted, have got to be read in its entirety. If we look at page 178, it refers to, well, before that, Chairperson, if I may, page 177 refers to the relevant sections in the Constitution. I won't go through all of them. It refers to sections in the NPA Act. And then at page 178, it states in the third paragraph, and whereas section 24(1) of the NPA provides that a DPP has, in respect of the area for which he or she has been appointed, the power to do various things. It just quotes the section again. If we go to page 179,
Just remember, you are trying to find a section that says Advocate Chauke acted in excess of his authority by getting involved in a KZN matter.
I'm answering the question.
Well, okay, well, show us then the passage.
I'm answering the question, Council. Sorry, Chairperson. Chairperson, at page 179, it states the issues to be determined by the inquiry are set out below. And then if we go to Roman 2, it says, insofar as it relates directly or indirectly to the conduct of Advocate Chauke and his fitness and propriety to hold office. Oh, sorry, that's not what I should be reading. Roman 2, whether in fulfilling his responsibilities as Director of Public Prosecutions, first bullet, Advocate Chauke complied with the Constitution, the National Prosecuting Authority Act, and any other relevant laws in his position as a senior leader in the National Prosecuting Authority. Chairperson, if we also look at the bullet on page 180, the second round bullet, and this may not be the only ones. Advocate Chauke exercised his powers and performed his duties. Well, before that, Chairperson, the first bullet, Advocate Chauke duly respected court processes and proceedings before the courts as required by applicable prescripts and as a senior member of the NPA. And the bullet next one, Advocate Chauke exercised his powers and performed his duties and functions in accordance with the prosecution policy directives as determined under Section 21 of the NPA Act. Chairperson, certainly it does not specifically state, those words are not used here, that he acted outside his jurisdiction, but everything that I've read indicates that very aspect. It requires Advocate Chauke to exercise powers as a DPP within his area of jurisdiction. And all of these paragraphs that I have mentioned must be read with the conduct when Advocate Chauke exercised powers that were not granted to him by the Constitution or the NPA Act, in that he exercised them outside of his jurisdiction.
See, Advocate Batohi, you've now summarized a new term of reference, which would have been one sentence. Why did you not include it in the draft?
Chairperson, I don't know. I can't answer that. So if it's a mistake, it doesn't mean this inquiry can't. The purpose of this inquiry is to inquire, in my humble view, into the conduct of Advocate Chauke. And certainly it cannot be if there was an oversight or if it was drafted in a way differently to what council thinks it should have been, that it should in any way constrain this inquiry.
So you see this inquiry as also fixing your mistakes and your oversight and your sloppiness in drafting.
That's your comment, and I will not respond to that.
But you are the one who said that merely because there was a mistake, merely because there was an oversight, should not constrain the inquiry. So it's completely justified for me to put it back to you that you see the role of this inquiry as fixing your mistakes, fixing your oversights, and fixing your sloppiness in drafting.
Council, you think you justified. I don't. We can agree to disagree on that.
Are you going to answer the question or not?
I disagree with that.
So you don't see this as the job of this inquiry to fix your mistakes and fix your sloppiness in drafting?
I do not see it as the job of this inquiry to fix my mistakes or my sloppiness.
Yes. Now, when you look at the draft letter from page 181.
I should add that that is your...
Pardon, Council. Council asked you a question, you answered, and he's now asking you another question, then you answers whilst he's asking you. I think it is important, Advocate Batohi, to accord one another the respect and just to observe the decorum.
I have absolute respect for Advocate Ngcukaitobi, Chairperson.
Well, you can say it, but you don't show it.
I apologize, Advocate Ngcukaitobi.
Look, there's no need to... anyway, thank you for the apology. Let me not poison the water already.
It's 11:15. You may pause where the apology is 11:15. You just pause where the apology is given, and you will continue when you reconvene after the tea adjournment.
Thank you, Madam
Chair. Remember the point where you stopped. and then we'll take it from there. We'll adjourn for tea
As you
until 25 to 12.
It uses no evidence.
That's correct.
Yes. That document, again, when it comes to the matter of Lieutenant General Mdluli, is limited only to the decision to withdraw the charge and to refer the matter to an inquest. It does not refer to the failure to reinstate the charge after the inquest or the failure to reinstate the murder charge after the judgment of Judge Murphy.
That's correct.
That document also does not mention anything wrong with Mr. Chauke's decision to instruct an appeal against the judgment of Judge Murphy in the matter of Lieutenant General Mdluli.
That is correct.
Yes. Thank you. Might we move on to the next topic? When we adjourned, there was a third issue to be dealt with, which was the question of the instruction to Advocate Hilton Epstein. Can I understand what your evidence is? Is it that you don't recall the entire interactions with Advocate Epstein or not?
The position is that I had interactions with Advocate Epstein. I remember that. I recall broadly that he had been briefed by Advocate Abrams in a number of cases, and the meetings we had dealt with the status of those matters generally.
Can you explain why you never disclosed this episode of the involvement of Mr. Epstein, despite you being completely aware of that fact?
I didn't think it was relevant at the time. But I'm here to answer questions. I'm happy to talk about it.
Yes, so it's not about having forgotten. It is about a deliberate choice that you will not disclose it because it's not relevant.
No, that's not correct. If I can please clarify that. It was not a deliberate choice. It's not like I thought about my interactions with counsel, Advocate Epstein, and decided not to put it in. That's definitely not the case at all. We were trying to put together my affidavit, and I think maybe we need to go back to the timelines under which we did this. And I think everyone is aware of that, so I won't go through it again. But I had a couple of days, amongst other things, an appearance before Parliament. I'm not making excuses. All I'm saying is that we tried to put in my affidavit aspects that we thought would assist this inquiry. And I'm not trying to withhold that. I didn't even think about Mr. Epstein at the time, but I'm happy to discuss any aspect of my meetings with him. I've got nothing to hide at all.
Now,
Madam Chair, with your permission, may I ask to interpose with respect to my learned colleague? I'm advised by the NPA team that at the time of the settling of the NDPP's affidavit, there was no instruction about the Epstein issue. And I'm asked to convey that and to put it on record.
I don't understand, Council. Are you suggesting that the issue regarding interactions between Advocate Batohi and Advocate Absence was not brought to the evidence leading team?
No,
Or what?
was not brought to the attention of the NPA, rather the attention of Advocate Hali at the time, and the evidence leading team as well, when the affidavit of the NDPP was settled. In other words, it is a response to Advocate Ngcukaitobi's issue that Advocate Batohi has not bring that to light in her affidavit, disclosed the interactions in her affidavit.
And Advocate Batohi sought to answer that question the way she did. Are you taking issues with her answer?
Not quite. I was just asked to put it on record. I'm not taking any issue with it. Her answers will remain. Those are her answers.
Shouldn't you leave this aspect for re-examination, because those are matters that you can clarify maybe in re-examination?
Yes,
Not now.
I agree.
Thank you, Madam.
I
Sorry.
see Advocate Halley is raising the hand. Would you please confer with him?
So we shouldn't encourage our solution. We were not didn't have rights to consultation, but we were also not advised about it. So the entire line of examination is based upon questions which we would not consult with our witnesses. I don't believe the examination of our witnesses ask them to
Madam Chair, Advocate Hali is requesting that he be given an audience on this aspect.
We will confuse this record. As you know, Senior Counsel, you will have an opportunity later when you re-examine. We cannot have cross-examination and re-examination at the same time. Might I request, through you, Evidence Leader, Advocate Mhlamunyane, that you take note of this aspect, and at an appropriate time when you re-examine, if you are minded to do so, you can raise whatever you want to raise.
I take your point, Madam Chair.
Yes, thank you.
Yes.
You may proceed, Advocate Ngcukaitobi.
Thank you, Madam Chair. Advocate Batohi, could you go to page 253 of file 3?
I'm there.
Yes. Now, that is an email that we received on Monday from Mr. Epstein SC. That was sent to you on the 26th of February, 2019, in preparation for a meeting to be held on the 6th of March. Correct?
It is a letter. It is an email from Advocate Epstein to myself, dated 26th of February 2019. That would have been about, I took office on the 1st of February 2019, so it's within that month. And I can't recall the meeting on the 6th, well, whether it happened on the 6th, but as I said, I had a number of meetings with him. So it might have been in preparation for that.
One of the documents that were given to you is the document that appears at page 254, which is a note prepared by Advocate Epstein and his junior Advocate Nkabinde.
I see that.
Yes. Now, in that note,
Advocate Ngcukaitobi, how do we know that this document at 254 forms part of a note that was prepared by Advocate Epstein and Junior? Just by mere looking at the document, how do I know that?
what they did, Madam Chair, at item 1 of 253, they did not only just extract if you go to 253, item 1, there are documents attached. And the first one that was attached is this document at page 1 to 5.
Please clarify it with the witness.
Oh, yes, thank you. Thank you for the guidance, Madam Chair. Yes. Advocate Batohi, we consulted, as you know, with Advocate Epstein to get...
I was not aware, but you did ask, and I had no issue with that.
Yes, well, we had asked on Monday whether there was an issue that you took on the advice that was given to you, and you said no.
That's correct.
Now, what he tells us is that in preparation for the meeting of the 26th, they sent several documents, which included the note on advice at 254 to 258, the document at 259, which was an extract from the affidavit of Mr. Sean Abrahams, and then references to case law, which you will find at 274, and then the prosecution memorandum at 278. Do you accept that, or you have no recollection?
My office has been trying to track the emails, and for some reason we were not able to go this far back. We were struggling with it. So we've not able to trace these, but he did brief me on a couple of occasions, and I don't have any reason to doubt that these documents would have been part of a pack that he would have sent to me. But as I say, I don't have any independent recollection of it.
Yes. Well, in the consultation, Advocate Epstein also read out to me and my junior WhatsApp exchanges with you, and I asked him not to copy those because I felt they would be too intrusive. Your evidence is that you have no recollection whatsoever of these emails.
No, I have no recollection of the contents, but we certainly had communications.
Well, you say you asked your office. I don't understand that. You asked your office to track these emails and they drew a blank.
Yeah, there's even the dates of the meetings. Our calendar, for some reason, was not taking us back to 2019. So my PA was having some difficulty actually getting the dates of the meetings as well. I don't know what the issue is.
So from your side, there's just nothing about 2019 on this particular issue.
I don't have anything in front of me at the moment. I'm seeing it now for the first time since then.
No, the problem with this is that there are other documents from 2019 that you produced for this inquiry.
Yes, that's right.
And then suddenly this one has drawn a blank.
See, the other documents were attachments or annexures, or they were attached to other documents. So we were able to, but I asked my PA to please try to trace the emails as well as the dates. And for some reason, we're not able to do that. I don't know why. I can't explain that, but it's in my interest that I have all of it.
No, I don't understand why you are able to get some documents from 2019. And then when it comes to these interactions with Mr. Epstein, which you never disclosed, you can't find anything.
I have no reason to hide my engagements with Mr. Epstein at all. I'm not withholding it for any reason. I'm telling you, I had the other documents that we may have got, like Advocate de Kock's report, was one that was attached to Dr. Broughton's annexure, his affidavit or his opinion. And I'm trying to think which of the other 2019 documents we would have had. But it's not like we searched for those documents now. I didn't ask my office to do that. I did ask them to check for all my engagements with Mr. Epstein, including dates of meetings, etc. And I don't know why we are struggling with it.
Yes. If we then come back then to page 254, just to understand, is your testimony that you have no recollection of page 254 at all?
I have no recollection of page 254 at all. I'm seeing it for the first time since I would have if it came to me then. I've got no reason to doubt that, but I'm seeing it now for the first time.
Yes. So what they told you, Mr. Epstein SC, as advice, of course you can say it's legal principles. Paragraph 1 and paragraph 2, those are the principles when poker certificates are issued because you asked for it. At page 255, they told you what you are entitled as an NDPP to rely on, which was one of the points of attack against the decision. They also told you, most crucially, what is the case against Mr. Boysen, Major General Boysen, at page 255, 256, right up to 257. They also told you to justify the rationality, because that was one of the issues that were challenged.
Please take it one step at a time.
Oh, sorry, I apologize.
For Advocate Batohi to respond, you referred first
But perhaps-
to 255.
Yes, we can go back to.
257.
Yes, Madam Chair, thank you for the guidance. We can go back to 255 so that we get an answer per question.
I would prefer to answer it completely. I'm making
Generically,
a note.
oh, I see.
I'm making a
Okay.
note. If you can go a little slower,
Yes,
it will help.
all right.
Thank you, Chairperson.
Yes. Now, the reason why they prepared this note is that you had asked for their views on the issue of the application brought by Major General Boysen, which had been defended by Advocate Abrahams. Pleadings were closed and the matter was due for argument. They sent you a short note to prepare for the meeting. Let's stop there. Any recollection?
I don't doubt that.
You don't doubt it? Yes. Now that note, as most legal advisory notes would say, starts off with general principles, paragraphs 1 and 2, which is page 254 and 255. Is that correct?
It does.
Yes. And one of the points that were attacked in that application is the question of the extent to which Mr. Sean Abrahams could have relied on summaries prepared by junior prosecutors. I don't mean junior in years, but junior to him. And then they gave an opinion on that at page 255, and that decision makers are entitled to rely on summaries, correct?
That's correct.
Yes. And then most crucial.
Where in paragraph page 254 is mention made of the reliance on junior advocates?
No, it is at
Remember
255.
You must remember, Council, we have presented these documents for the first time to us this morning,
Yes,
meaning we have not been able to go through it.
I appreciate it.
So give us the details as you ask questions and take us to the relevant points as regards your questions.
Yes, thank you, Madam Chair. So if you go to 255, under decision makers are entitled to rely on summaries, it says, this is a principle of law, and they're explaining to you why it is correct. They say this is consistent with the wealth of authority affirming that decision makers are entitled to rely upon summaries of underlying material prepared for them by their subordinates,
It's correct. It's a point that I've also made at this inquiry.
who are well versed in the matter and whose judgment and ultimate decision maker is.
I beg your pardon, Council. You just made a remark. What are you saying, Madam?
I said that is correct. It is also a point that I've made at this inquiry. So I agree with that.
But you answered the question whilst Council is busy continuing with the question, or did I misunderstand you? Advocate Ngcukaitobi?
Yes, I had not yet finished, but we can live with the answer that the witness accepts the proposition.
It does help us because we are recording
Yes.
your questions for our own purpose and the answers, Advocate Batohi. It will be helpful if you can just take a deep breath and wait for Council to finish. Because you write a question and before it is concluded, you answer. It is making it difficult for us.
Understood, Chairperson.
Yes.
You may proceed, Council, maybe from where you were,
Yes. Thank you.
so that you can get the answer from Advocate Batohi.
Yes. After the word subordinates, comma, who are well versed in the matter and whose judgment the ultimate decision maker is entitled to trust. So that's the advice they gave you on that issue, correct?
It's there. It's in the document.
Yes. And then one of the most important issues, I wanted to come to this page 255, that Major General Boysen kept on repeatedly saying publicly that there is no case against him. They then sought to condense the case for you. What is the case of the NPA against Major General Boysen? Now that is stated at page 255 under the heading, the case against General Boysen. And then they explain to you in paragraph 1 that the applicants challenged the decision of Advocate Abrahams to prosecute Boysen on counts 8 to 12, the 5 predicate offenses in the indictment. And then they explain what the defense of the NPA is. From paragraph 2, paragraph 3, paragraph 4, paragraph 5, 6, 7, 8, 9, 10. They also even, at paragraph 10, give you the basis for that case, the factual basis for that case.
At paragraph 10.
Yes, paragraph 10, page 256. They say witness statements are relied upon, as well as a statement by Danikas, a police reservist who worked closely with Boysen, and corroboration by ballistics reports supporting the allegation that those killed were not in fact resisting arrest when they were killed. Now, those 2 pages are pieces of advice to explain in very condensed format what is the case against Mr. Boyson. And they're doing it to prepare for the meeting of the 6th of March. Is that correct? That's the advice they gave you?
That is the advice that they provided in this document.
Yes. You then turn to page 257. Now it's going into a different topic, because one of the issues is to challenge the rationality of the decision by Advocate Abrahams. That is covered under the heading, the decision made by Advocate Abrahams to issue the Section 2 poker certificates. And that's paragraph, they even tell you there, a presentation to guide Advocate Abrahams through the evidence was made to him on the 27th of August, 2015. It is an annexure, JB 27. Then Advocate Abrahams told the prosecution team that he wanted additional information to be obtained and investigations pursuant thereto to be conducted. Advocate Abrahams requested a list of items. After these were furnished to him, he was not satisfied and instructed Advocate Maema to travel to Greece to consult with Danikas. Then paragraph 4, Danikas supplemented his statements and handed Maema additional photographs and video clips on flash disks. Dawood Adam and Advocate Maema briefed Advocate Abrahams regarding their consultations. He was handed a copy of Danikas' supplemented statement, and he was shown certain photographs and video clips on the flash drives concerning the manner in which the Kaitomana Serious and Violent Crime Unit dealt with suspects. And then Advocate Abrahams then issued the poker certificates. Now, I asked him about this. This is to explain the rationality of the decision by Advocate Abrahams. Do you accept that that's the advice you received?
This relates to the rationality, yes. And that's an important point that you make.
Yes, yes.
It's not about the correctness, it's about rationality.
I understand, but this is the advice they're giving you.
Sure.
Yes. And then the final page.
Sorry, Advocate Ngcukaitobi, can we seem to be getting answers, but one is not clear whether the witness accepts that this is the advice that was given to her or not. Her latest answer is sure. So I don't know where to place
Okay.
sure.
Thank you, Madam Paloimere. Could you answer expressly? I am putting to you that this page 257, under the heading, the decision made by Advocate Abrahams, was the advice given to you on the rationality of the decision by Advocate Abrahams by Mr. Epstein SC. Yes.
That is correct.
And then they sum up the whole thing at page 254 by referring you back to legal principles.
Sorry, at what page?
258, sorry, I think, or did I say 254? Yes, page 258, which is the last page where they sum up these requirements by reference to section 2, subsection 4. And there they draw your attention to the reasoning of Judge Scott J.A. And in the judgment, firstly, there's a judgment of the Western Cape Division in paragraph 1, S versus Chau, and that judgment is already referenced earlier at 254. Can you see that?
Mm-hmm.
Yes. Then they support it with another authority, NDPP versus Moodley and others. And then paragraph 3, to sum up why they believed that the decision was defensible. Can you see
Sorry,
that?
where's the sum up?
This is the sum up, what I'm referring to you, because it's under the heading, the requirements for a section 2.4 poker authorization, page 5.
They set out the requirements there.
Yes, yes, page 258, correct?
Yes, they mentioned 2 cases and set out the requirements.
Yes, exactly. Now, this note is given to you because you've asked for it in preparation, because you want to understand the strength of your case, correct?
That is indeed so. I wanted to understand the position that they were taking and the reasons for it.
Exactly. You know, when I asked you on Monday, are you sure that you never received written advice from Mr. Epstein SC? You started by saying, no, you didn't. Then later on, you said, no, I don't recall. Now we know for a fact that you did receive it.
That is so, I couldn't recall. As I said at the time,
Beg your pardon, Advocate Batohi. What is your response?
Chairperson, my response is, as I said, I could not recall. And I want to clarify that I was very clear that I had meetings with Mr. Epstein and that I received documents from him with regard to cases that he was handling at the time for the NPA. So, that was what I could recall. Maybe the specifics of it, I couldn't, but I certainly accept that he had given me these documents. At the time, he provided me with documents.
You see, the problem, Advocate Batohi, you've given us so many opinions from your office that you obtained. And on this issue of whether there was a good case or a bad case, or at least what the case was, let me not, because I suppose you will disagree if it was a good case, but at least what the case was and what the defense was. You've just not produced this advice from Mr. Epstein. Now, that I find extremely difficult to understand, why you did not volunteer these interactions and this opinion. If you are saying there was nothing untoward, then I ask myself, why then not disclose it?
There is still nothing untoward about it. And I've explained, I thought, why, we didn't provide it. And as I say, this is the first time I'm seeing it, but I was candid when I was asked about it, that we had had meetings and he had briefed me on all the matters that he was handling. And of course, this was one of them.
Well, we will have to look at the record about whether you disclosed that there were meetings. I thought I introduced Hilton Epstein SC into the discussion, not you.
No, you're right. In fact, you did. If my recollection is correct, that you did. And I said, when I was asked these questions about it, I answered it as candidly as I could.
Yes. Now, the other documents from 254, right up to from 259 to 333 were also part of that attachment. We can see from the email cover that they were part of that attachment. 259, Madam Chair.
259.
Up until 333.
What about them?
I'm saying to the witness that they were part and parcel of that email exchange that is referenced at 253, correct? Actually, it's not an exchange. It's
Sorry,
Mr.
my
Epstein sending
apologies.
you an email.
I was just looking at all of the attachments, and I do see a minutes of meeting of 6 March as well, which I haven't seen.
Well, I'll come back to that minute. I just want to look at the attachments.
Chairperson, I asked that I be given an opportunity to read all these documents and then deal with them, because it's the first time that I'm seeing it. And I think it would be fair for me to have a look at these documents and then be subjected to questioning on it.
In fairness to Advocate Batohi, remember, we all have these documents only this morning. And I'm sure she would like to refresh her memory, as we wish to also, because we have not read the documents. It may just be useful for her in particular to reflect. If it is possible, you may park this question hopefully it's not going to inconvenience you or distract you from your course, just to enable her to reflect on these documents, particularly from 259 to 333.
Look, Madam Chair, if she's going to reflect, she must reflect up until 353.
353.
Yeah, so that we don't come back and then stand down again for another questioning. Madam Chair, I have no difficulty that a witness who's asking for time must be given time. I want to record one thing. These are documents that were sent to Ms. Batohi in 2019. In other words, these are her documents. She wants to read them, fine. And my position is they are so crucial to the topics that come thereafter. So if she wants to read, she can read them, but I would like to continue questioning her on these documents before moving to the fourth topic.
These are the documents that, I beg your pardon. These are the documents that were sent by Advocate Epson
Yes.
team to her in preparation for the meeting of the 6th of March,
yes.
2019.
2019, yes. But as I say, the principle that a witness wants time and must be respected, I accept that.
Thank you, Counsel, for understanding. Advocate Batohi, I beg your pardon. Let me just confer with my sisters. Advocate Ngcukaitobi, as you understood that it is fair. Advocate Ngcukaitobi, as you understood that it is fair for Advocate Batohi to go through this document, would we be able to proceed then on another aspect? Or will it be necessary for us to adjourn to enable her to go through these documents in preparation for your next questions?
Yes, Madam Chair, I don't know how long she needs, but it shouldn't be more than an hour to read through this document. So I'm happy to adjourn until maybe 2 o'clock, and then we can commence thereafter.
We are minded to enable her to go through the documents then until after lunch, because we will reconvene and then immediately after that hour, it will be lunch. Advocate Batohi, how much time do you need to reflect and read this document?
Chairperson, I might not be as fast a reader as Adv Ngcukaitobi, but I think let's, up until 2 o'clock, I'll certainly do my best to go through all of it and be ready at 2 o'clock.
I'm just thinking, Council, that lunch may not necessarily be ready when you adjourn now. So it may be helpful as we afford Advocate Batohi sufficient time to also just use that moment to wait for lunch, so that when we reconvene, we would have had lunch to avoid many adjournments. I think that will afford you sufficient opportunity, madam, to reflect.
I hope
and,
so, Chairperson. I'll do
go
my
through
best.
the documents. It will definitely be more than an hour. In that event, Advocate Batohi, we bear in mind that these were the documents sent to you in your office in 2019. Of course, it's a long time ago, but you are aware that there were such documents. So it's not like a totally new documents that you don't know of. Nonetheless, we will afford you 2 hours, not an hour, 2 hours to go through the documents so that we do not take another adjournment after lunch. We will therefore adjourn now for that purpose, and also to have lunch during that break and reconvene at 2:30. We adjourn.
As you please.
Adv Chauke, good afternoon. You are still under oath, Madam Advocate Ngcukaitobi. You may proceed. I assume that you managed to
I did, Chairperson.
go through the documents. You may proceed, Counsel.
Thank you, Chair. Advocate Batohi, from page 259 to 271 are extracts from the answering affidavit of your predecessor, Advocate Sean Abrahams. Is that correct?
That's correct.
Yes. And in those extracts, he sets out the basis for his decision to issue the Section 2 authorization, Section 2 of POCA.
That's correct.
Yes. He also pertinently responds to the criticism by Judge Gauteng. Correct? At page
Yes,
263.
He gives his response to that.
Yes. He also answers the allegation that Advocate Hodes SC made concessions from page 266.
Yes, he does.
Yes.
Counsel, this affidavit by Advocate Abrahams was made in which proceedings?
Madam Chair, I think we will have to just submit. We've got the affidavit together with this annexures.
Yes.
We will just have to hand it to the panel. There were two proceedings challenging the authorizations. Proceedings number one challenged the authorizations under Advocate Jiba, and they were set aside by Judge Gauteng. When Mr. Abrahams took over, he reissued those authorizations. Mr. Boysens then challenged them again. So in those second review proceedings, there was a comprehensive 175-page answering affidavit filed by Advocate Abrahams. So it's in those proceedings that we extracted well, it was not extracted by us, it was extracted by Advocate Epstein for the benefit of Advocate Batohi.
Thank you very much. That helps.
Yes, thank you, Madam Chair. And then the third feature of this is that he also refers to the findings made by the full bench in the case of General Counsel of the Bar versus Jiba from page 269. Is that correct?
That's correct. He does.
Yes. And at page 272 to 273, I think that this may be a duplication because we've looked at the extract from the Act itself, 272 to 273. Can you see that?
I see it.
Yes. So you can skip that, and then he gives you a copy of a judgment called S versus Prinsloo with specific extracts, I think from paragraph 45, from paragraph 45 to paragraph 68, which is at page 276 to 277. Correct?
He does that.
Yes. And then the last document is then the prosecution memorandum of Advocate Mayema from page 278 to 333.
Yes, that's correct.
Yes. So those are the documents given to you by Advocate Epstein to empower you for the consultation on the 6th of March, 2019, correct?
That's correct.
Now we then go to the meeting itself of the 6th of March, 2019. If we can start at 334. Now, this is a minute prepared by Advocate Nkabinde, who was the junior counsel to Advocate Hilton Epstein, but which has been read and endorsed by them as being the accurate recollection of what happened. They prepared this in 2019 already, on the day of the meeting, on the 6th of March, correct?
I can't dispute that.
Yes. And
Pardon, Advocate Ngcukaitobi. Advocate Maema's affidavit or memo,
statement, yes.
a memorandum rather, where does it start?
I think the extract, Madam Chair, starts at 278.
278.
Yes,
278.
yes.
Please bear with me. Just want to check something.
Indeed.
Oh, thank you. Up to 277 is State versus Prinsloo.
Yes, there are only 2 pages of S versus Prince
Yes,
Law. It's 276.
Yes, thank you very much.
Thank you, Madam
Thank
Chair. Now, if we just go back to the minute of the meeting held. Now, in this meeting, you invited Mr. Carl van der Merwe, who was the attorney for Major General Boysen, and Advocate Anton Katz, SC, who was the senior counsel for Mr. Boysen. Is that correct?
They were part of the meeting.
No, you're not answering my question. You invited them. They didn't just show up,
No, they were part of a group of people that were invited to the meeting.
but they were invited by you.
Yes, they were invited by me.
Yes. Now, when you invited the legal team of Advocate Boysen, you had not consulted with the prosecution team, your own prosecution team. Correct?
That is correct.
And you did not invite your own prosecution team to that meeting.
That's correct.
You had not consulted with the investigators in the matter.
That's correct.
Yes. You did not invite the investigators to the meeting.
That's correct.
You had not consulted with the complainants.
I didn't think there was any need for me to consult with the complainants.
Just answer my question. You
I
had not
didn't.
consulted with the complainants.
I did not.
Yes.
And who will be the complainant?
It will be the families of the deceased.
All the deceased families, let me rephrase. The deceased in relation to the 28 dockets.
Indeed.
Yes, thank you.
Thank you. Now, at page 336, if you count 1, 2, 3, 4, the 4th column, which says SB, we asked the author of these minutes. SB refers to Shamila Batohi. 336. Yes.
How does the fourth column read?
It says, okay, but I understand. Yes. You say, okay, but I understand. People are angry and the NPA has behaved badly.
Sorry, I'm not in the same place as you are.
So it's 1, 2, 3, 4. It's
On page 336.
page 336, yes.
Yes.
Yes, where it starts with okay,
Yes.
but I understand people angry and the NPA has behaved badly.
Mhm.
You already condemned the NPA as having behaved badly, but we know that you had not done any investigation at that stage. Is that correct?
I think we need to look at the context of that comment. That comment is made in the context of, we were discussing a number of, the purpose of the meeting was to discuss other matters as well. And if you look at what happens before that, we are referring to the Pandey matter, because I see Madhu's name is there. He was one of the accused in the Pandey matter. In fact, you'll see on the first page, Counsel Epstein says, "Can I come and see you at a later stage regarding Madhu and Pandey?" And that is the matter we are discussing. And so that comment, the Boyson matter starts after the comment. The comment is made with regard to other cases. You see, Mr. Epstein says, "Van Lochenberg, we received a very aggressive letter. Perhaps I should come back to you and talk to you." My response then is, "Okay, but I understand people angry and the NPA has behaved badly. 3 deputies from the PCL, that's incorrect, actually it should be the PCLU, are going back to where they came from, including Maema. Concerning discipline, I will look into that. I need to apply my mind." So having read all of that, I think it relates to all of these matters, well, more than just the Boyson matter.
I think you are not answering my question. At that point, you had not done any investigation.
Into the Boyson matter?
Yes.
As indicated?
Yes.
I had not.
Yes. Now, you mentioned the 3 deputies from the PCLU that will go back to where they came from, including Mr. Maema.
Mm-hmm.
Now, you had not consulted with Mr. Maema or these deputies before you made this comment.
That's correct.
And then you mentioned discipline. Who are you planning to discipline?
I said, concerning discipline, I will look into that. I need to apply my mind. I had not decided on anything at that point. I need to indicate again the context within which this was happening. There was the Zondo Commission that was ongoing, and a lot of evidence had been led there about possible capture of the NPA. And the team that was dealing with these cases that were allegedly the result of capture were the cases that this team was dealing with. And it was on that basis I said, I will look into it. I need to apply my mind.
Okay, just answer my question. Who are you referring to when you say discipline? Surely there must be an employee that will be subjected to discipline.
There will be employees that I will apply my mind to with regard to possible discipline.
Who are those employees?
It is Maema. Matendra was another deputy. It was the team that was dealing with a number of these matters.
So already within a month of your arrival, without any investigation, you had already had a list of people to be disciplined.
No, I didn't have a list of people to be disciplined. I had a number of people against whom there were lots of allegations in the public, and I had said I need to look into that and apply my mind.
Yes, but the point is that you already put them under the bracket of discipline. And I asked you who these people are. You've given us Mr. Maema, Mr. Matendra. And I ask you, as a responsible NDPP, how you could talk of discipline without any form of inquiry at all.
Because there was a lot of allegations in public about capture of the NPA. I needed to consider the matter. I had made absolutely no decision about discipline, and I will not make a decision about discipline without any evidence at all.
Yes, all right. Other than those 2 employees, Mr. Matendra and Mr. Maema, who else did you think fell into this category of discipline?
There were a number of staff members that were potentially compromised. It would be Maema, Matendra, JJ Malochwa, Advocate Mozing,
Yes.
And I'm not sure about others, but all of them are currently undergoing disciplinary proceedings.
Now you say that the basis for
And
you.
these, I beg your pardon, these people that you refer to by names are advocates within the NPA.
That is correct, Chairperson. Well, some of them have left since, but they were at the time.
They are nonetheless advocates.
Yes, that's correct.
Now, just explain to me, you say that the basis for the allegations, or at least the basis for the reference to discipline, was because of what had been stated at the Zondo Commission, correct?
Pretty much, I would think, casting my mind back 7 years, I would imagine that is what it was.
By who?
I beg your pardon?
Who said things about these people that warranted the reference to discipline at the Zondo
I
Commission?
can't say who said what. It was public knowledge at the time.
Well, surely you can tell us that so-and-so had made allegations against Advocate Matenjo. So-and-so had made allegations against Advocate Mayema.
I can't say that.
Was General Boyson one of the people that made allegations against them?
I can't recall.
Was Advocate Ngasana one of the people who made allegations against them?
I can't recall.
You see, it is extremely difficult to make sense of your evidence when you say there were allegations of capture against Advocate Matenjo and Advocate Mayema. And I asked you from who, you cannot recall. And I ask you the nature of these allegations, you also cannot recall. It makes me believe that there is simply no basis for the claim that you have made, which is why you cannot recall when I ask you about detail.
That's your opinion?
Well, help me to disabuse my mind of this view, because I've given you two potential candidates that could have made these allegations because they testified at the Zondo Commission, Major General Boyson and Advocate Ngasana.
I said I can't recall. There was a lot that was in the public space at the time.
Yes. Can I tell you the problem with the references to the State Capture Commission is that General Boyson's evidence was only given on the 16th of April, 2019. Did you know that?
No.
Advocate Ngasana's evidence at the Zondo Commission,
Please repeat that.
it was given on the 16th of April, 2019. That is Major General Boyson.
2019
Yes,
at the Zondo
at the
Commission.
Zondo Commission. Yes. Now, Advocate Ngasana's evidence was only given on the 11th of June, 2019 at the Zondo Commission. Did you know that?
I was not aware.
Yes. And you were already making these statements about discipline on the 6th of March, 2019. Now, if we go further at page 336, immediately after you have...
Sorry, Advocate Ngcukaitobi. Were you expecting a response from the witness, or you were just putting a statement and moving on?
I think it's common cause that she was making those allegations on the 6th of March, 2019.
But she didn't respond, she didn't react, or you didn't give her a chance to
All
react.
right, thank you. Do you want to respond, Advocate Batohi?
No, there's no need to respond.
Okay. Then immediately after you have spoken, HE, we asked the people that gave us this minute, is Hilton Epstein, who says, on the Boyson matter, I spoke to Katz, and we are told that is Anton Katz SC. Here is the amended notice of motion, and then you read it out. So they want the decision to issue poker certificates to be set aside. The latest position is, he said that this is my view. So already at that meeting, there was a draft order to set aside your decision, correct? Not your decision, the NDPP's decision.
I can't remember what it was, but from the note, it says here is the amended notice of motion.
Yes.
So I don't know what that was about, but certainly council was speaking and they brought something to the meeting. I couldn't prevent that.
I'm not sure what you mean when you say you couldn't prevent. You had invited Mr. Katz, you had invited Mr. van der Merwe. You had a reason to invite
I
them.
invited everybody. I can't recall what the circumstances were, but I invited my council, their council, and I can't remember what actually led to the meeting and how it came about, as well as the state attorney was also there. I think that was the state attorney. I think looking at the list in front, I think Joseph Sibelemetsa, I think is the state attorney. And so they came to the meeting, and what they brought with them, I couldn't control. So yes, that was what was at the meeting. I did invite them. There's nothing wrong with that, but I don't know. I couldn't, they brought what they felt they needed to.
Advocate Batohi, don't say things that have not been put to you. Nobody is saying there's anything wrong with you having invited them to the meeting.
Mm-hmm.
Would you please confine yourself to the questions that are put to you? Because when you answer broadly, you invite questions from us to seek clarity from this elaborated or rather expensive answer you give. Would you please just confine yourself to the questions?
Chairperson, with all due respect, I think this is a fact finding, and I'm really trying to give the facts as I understand, but I will certainly try to be shorter.
I know we are all searching for the truth, but we are also trying to record your answers to the questions, pertinent questions that are put to you. You may just ask if there's a need to elaborate, but when you just answer, sometimes I'm not even sure what you are answering, and it makes it difficult for me to follow your evidence. Would you please confine yourself to the questions? And if a need arises that you want to elaborate, seek my guidance. Then we will do so. But I'm trying to write your answers to the pertinent questions that I asked to you. Otherwise, I'm just writing and I'm not even sure what I'm writing here. Would you please do that to assist us?
I will try to assist you. I will try to assist, Chairperson.
Thank you, Madam Chair. Advocate Batohi, let's just go back to make sure we have a clear answer. What I'm putting to you is that the draft amended notice of motion concerned the decision to issue the poker certificate being set aside. That much is clear from what Advocate Epstein said. Is that not correct?
That's clear from that, what is written there.
Thank you. Then you respond, which is why I put to you that you actually knew about Mr. Carl van der Merwe and Mr. Katz coming. You say, I bumped into them this morning, meaning Mr. Katz and Mr. Carl van der Merwe. But I know Carl from Durban. Do you remember this?
Well, I must have bumped into them that morning, but when you asked me about it, I couldn't remember, and I couldn't even remember the meeting. But clearly, I bumped into them that morning before the meeting.
Accidentally?
However, I don't know.
Of people you have invited to the meeting, just bumping into them
I can't
accidentally?
even recall where I bumped into them, frankly.
That's the oddity of it, is accidentally bumping into people that you have invited into a meeting before you've even met with your own counsel.
I can't respond to that.
Now you say, I know Carl from Durban. What does that mean?
I know Carl van der Merwe. He's a lawyer from Durban.
But what is the extent of your knowledge of him?
I know Carl, for many years in Durban. I was a prosecutor. He was a criminal lawyer. And there were many cases where we were against each other for many, many years.
Yes. Were you friendly with him?
I'm friendly. Well, I don't know how you would describe friendly, but I hadn't seen him for many years at that time, but we had a good relationship, as I do with many defense counsel.
So you had a good relationship with him.
Well, yeah.
What about General Boyson? Did you know him before this case?
I did know him before this case.
Know him from where?
He was a police officer in Durban. I was a prosecutor. And I must say, I didn't really know him well, but I did know him.
You knew him. I don't understand when you say he was a police officer. That much is a notorious fact. What I'm asking you is whether you had any interactions with him in the course and line function of your duties.
I did have interactions with him.
You were the Director of Public Prosecutions in KwaZulu-Natal until 2009. For how long were you the Director of Public Prosecutions?
From 2002 until 2009.
And during that period of 7 years,
Wait a minute, please. From which period to
2002 to 2009.
2009?
yes.
Thank you.
During that period of 7 years, you became acquainted with Major General Boyson.
I'm not sure what became acquainted with him means, but I certainly knew him because he was in the police force, and yeah, I got to know him at that time.
I asked you, when I say acquainted, it's based on the answer that you gave when you say you had several interactions with him in the course and scope of your employment.
I can't recall several, actually. I must think back. This is a long time. Because to be frank, he doesn't stand out as someone that one of the investigators that was involved in any of the cases. I honestly can't say that I had a lot of interaction with him, but of course, I don't know if he was the head of the unit at the time, but I knew of him, and I am sure I would have met him in certain contexts.
Yes, not only was he the head of the unit of K2 Manu, he also became promoted in 2007 to be the provincial head of serious and violent crime of the province. So even in that capacity, you would have interacted with him on several occasions.
I'm not sure. I used to interact more with Commissioner Brown, who was his superior. I know we met in meetings, and I had my interactions were a lot with Commissioner Brown, but I can't remember Boyson.
Sorry, Advocate Batohi, if I'm sounding confused, it's because I am. I thought you had admitted that you had interactions with Major General Boyson in his capacity as the head of the serious and violent crime unit at...
I'm sure I would have.
Yes, and I thought this is the only thing I was adding, is that those interactions would have been strengthened by the fact that he was holding a provincial position.
No, I didn't really have a close relationship with General Boyson. I must have had interactions. I can't even remember specifically, but I'm saying that because he was a police officer in KZN. But Commissioner Brown was a person I had a lot of interaction with.
Okay. Well, Advocate Batohi, this is not an inquiry about Commissioner Brown. It is an inquiry about Major General Boyson, if we can confine ourselves to that. Now, when you say you had several interactions, in what context were those interactions? What were you discussing?
I can't recall. In fact, I may have used the word several, but as I said, I don't recall having a close relationship with General Boyson, and I can't recall in what contexts we would have had conversations.
No, you did not speak of conversations in your earlier answer. You spoke of meetings. I'm asking you, what were those meetings about?
I'm not even sure if I've had meetings with him. All I'm saying is that he was the head of a unit in police. And I'm just, because it's casting my mind back 15 or so years ago, away, longer than that, I'm just, I'm not sure, I can't recall what these interactions or communications were. And I'm trying to answer as best I can.
Advocate Batohi, you are the one who introduced the concept of meetings. I was simply talking about being acquainted with him. And then you said you would have had several meetings in his capacity as the head of the unit or as a senior policeman.
I'm not sure if I used the word several, but we can look
All
at that.
That's fine. Let's say meetings then, certainly plural.
I said I assume I would have, but I cannot recall that I did. But as I said, to clarify, and I know you say don't speak about Commissioner Brown, but he was his superior, and I had a lot of meetings with him.
Yes. Now, I think where we got stuck is you remembering meetings, but not remembering the content of the meetings. Your final answer is you remember the meetings, you don't remember the content of the meetings.
I honestly can't even remember the meetings.
And your first answer that you had meetings with him was a false answer.
Wasn't a false one. I'm not trying to mislead this. I'm trying to recall events way back 20 years ago. So it's difficult.
Yes. Anyway, so when you come to that meeting of the 6th of March, you have Mr. Carl van der Merwe, who you volunteer acquaintanceship with, and you have Major General Boyson, his client, whom you say you knew before. Is that correct?
That's correct.
Yes. Now, then Mr. Epstein tells you, immediately after you've said you had bumped into Mr. Carl van der Merwe, that Mr. Katz's view is that he wants you to withdraw the poker charges against everyone. We can continue with the predicate charges because there isn't enough information. The interdict won't carry on, is banking on the NDPP not issuing new poker certificates. You can later reinstate. He is now narrating the demand from Major General Boyson communicated through Mr. Katz SC. Is that correct?
That's their demand.
Yes. Look at your response.
I beg your pardon, at 335, 1.4, is that the same Advocate Katz who is mentioned there? TM. Is it somebody different?
No, Madam Chair, you will see when he enters the meeting, he has not yet entered at this stage.
He's not yet there.
Yes, he's not yet there. This is Advocate Batohi, only with his legal team. Yes. So, Advocate Batohi, you see at this point, the demand has been set out about what they want. But look at how you respond. You say, I would do something like that. It would look like you don't know what you are doing. If it stands now, and if it's withdrawn, that's it. So your answer, when you are told what their demand is that you would do something like that, and you don't want to appear as if you don't know what you are doing.
I can't vouch for the accuracy of this transcript. What I would say is that I would never, ever simply accede to the demand of any counsel, ever. I would consider evidence and facts. It's not the way I work. If you read that, it says, I would do something like that. Then I go on to say, it would look like you don't know what you're doing. My inclination is that I would have said, I wouldn't do something like that. It would look like you don't know what you're doing.
Yes, thank you very much.
So that's definitely not what I would have said.
Yes. And then he responds, Advocate Epstein, the following page at 337, about costs. We can leave that, it's not particularly germane. In the end, the order was without costs. But I'm interested in what you say thereafter. You say we will have to look whether the poker certificates were properly issued. The decisions of the NDPP on these matters are being tested. I need to assess the evidence. On the one hand, I get a sense that with the mechanism, if the victims get justice, strategically, this case, if racketeering stands, they will have to take my decision to the end. I'm not afraid of it being tested if the decision is taken properly. If I have that view, I don't need to do anything, it just proceeds. And now, this is the part I want your comment on. They are taking SKA's decision on review. Now, that is Sean Kevin Abrahams, correct?
That is correct.
Yes. It's the worst case to take on review. SKA's credibility has a bad perception. It's there. This case, imagine a judge saying this, Jiba, Sean, etc. They will say it was not done properly. Can I just ask you to explain why immediately you believed that simply because the decision is taken by Advocate Jiba and Advocate Sean, a judge would immediately say it was not done properly?
I have to say that I have an issue with us thinking that accepting that this transcript is accurate in every word. Because if you look at the top of that very same part that you've read, it just doesn't make sense what is written. It says, on the one hand, I get a sense that with the murkiness, if the victims get justice, strategically this case, and it ends. It just doesn't make sense.
Yes.
So my point is...
No, there is a later part where you explain the strategic part. That's why I have not asked you. Can you just focus on what I've asked you?
My point is, Chairperson, please, can I respond? Because I am being asked details about a transcript that, in my view, I cannot even recall. I don't know if it's accurately captured. And I am being asked to answer questions as if it is accurately captured. So I should be given an opportunity to deal with it with that understanding that it may not be accurately captured.
Adv Ngcukaitobi, I think take it one step at a time. Maybe we can just capture that portion you read.
Yes.
And then so that she can respond to that very portion. And as I cautioned also Advocate Batohi, just confine yourself to the question. If you need to elaborate, you may request that you do. May we then capture that portion that was read to you, and then you can comment or answer.
Yes.
Would you kindly read that portion that you focused on, Council?
Yes, thank you, Madam Chair. It's the sentence that starts with, they are taking SKA's decision on review. It's the worst case to take on review. SKA's credibility has a bad perception. It's there. This case, imagine a judge saying this, Jiba, Sean, etc. They will say it's not done properly. I just want to understand that part. On what basis could you allege that simply because a decision was taken by Advocate Jiba and Advocate Abrahams, a judge will say it was not taken properly?
I can't say that because a judge must consider the case before him or her.
So this would just be your own prejudices and biases?
No, I'd say it has not been captured properly.
Because part of the problem with this, there was never any credibility finding against Advocate Abraham. Never any findings at all in any forum that he had done something calling into question his credibility.
Credibility doesn't only depend on what's said in fora.
May you please answer, was there any such credibility, I beg your pardon, was there any such credibility findings made anywhere?
Not that I'm aware of, Chairperson.
Thank you.
Yes. And even if we talk about Advocate Jiba, by March 2019, even the decision of the Judge Mokgoro Commission was not yet out. It came out only in April 2019.
I suppose, Counsel, he says there has not been any credibility findings against them. So doesn't that answer? Doesn't that also covers the Mokgoro Commission's findings, which then followed later?
Yes, and in fact, it gets stronger with Advocate Jiba. At that point, she had been reinstated by the Supreme Court of Appeal as an advocate after being struck by the High Court in Pretoria. I come back to this Advocate Batohi. You seem to be expressing opinions about people based on nothing other than your own prejudices about those people.
I disagree.
Yes. Now,
Let me say I have no prejudice against Advocate Abrams, Advocate Jiba, or anyone. They may be very good people. I have absolutely nothing against them.
well, you've just told us that a credibility finding does not require a formal inquiry. But I ask myself the question, where is the credibility question around these two advocates?
At that point, we had had the Gorvin judgment. Advocate Jiba had been charged. But as I said, I'm still not making I don't have a personal issue with either of them, with any one of them. They are probably very good people. But I'm dealing with the evidence and what was before me at the time.
Yes. When it comes to Advocate Sean Abrahams,
I beg your pardon, Counsel. Advocate Batohi, I think these questions arises from that sentence where you refer to SKA's credibility. I think this gives rise to all these questions that Counsel is asking you.
Mhm.
And as lawyers, we know when you speak about somebody's credibility, what do you mean? His reliability, his honesty, and all those factors. The question then arises, as Counsel asked you, and you answered, that there is no way, neither during the Mokgoro's commission, where was his credibility questioned. And then that begs the question, why were you talking about Advocate Abraham's credibility at that stage?
Chairperson, there was a lot in the public space at that stage, and he had also been removed from office by then. Well, he was forced to vacate office, I think. I don't know what exactly happened, whether he was removed or forced to vacate as a result of a court decision.
As a result of
A court decision.
a court decision.
I don't know which case it was exactly. It was the Ngasana matter, I think it was.
now, can I just deal with that part? You say there was a lot in the media, or there was a lot in the public space. I don't think you said media, you said in the public. And that he was removed as the NDPP. Do you know the basis on which Mr. Abrahams was removed as the NDPP?
I can't recall. I can't recall precisely.
But you have no qualm telling this august panel that it related to his credibility, even though you don't know why he was removed.
No, it's not that I don't know why he was removed. I said I don't know precisely why. if I recall, and again, I'm trying to think what I'm actually not so keen to say something here if I'm not really sure about it. But I think it was the Ngasana decision that dealt with Advocate Ngasana, his vacation from office and the appointment of Advocate Abrahams, and the rationality of the president's decision in that regard, if I remember correctly.
Can I read to you paragraph 88 of the Constitutional Court judgment, which dealt with this matter pertinently? It says,
Which matter?
the matter of, Madam Chair, that's a good question, actually. I need to find the actual reference. Thank you. The judgment is Corruption Watch and others versus President of the Republic of South Africa and others, reported in 2018, volume 2, SACR, page 442. Now, paragraph 88 deals with Mr. Sean Abrahams, Advocate Sean Abrahams, pertinently. This is what it says. I next deal with Advocate Abrahams. As a point of departure, I must state that not a single party has suggested that he is not a fit and proper person to hold office. As was to be expected, Advocate Abrahams seeks to get a lot of mileage out of this. Must he succeed? I think not. Former President Zuma appointed Advocate Abrahams following his unlawful removal of Mr. Ngasana. That removal was an abuse of power. Advocate Abrahams had benefited from this abuse of power. It matters not that he may have been unaware of the abuse of power. The rule of law dictates that the NDPP be cleansed of all of the ills that have plagued it for the last few years. It would therefore not be just and equitable to retain him, as this would not vindicate the rule of law. Seems to be quite clear that the judges themselves are clear that this removal has nothing to do with his fitness for office. It is simply because President Zuma didn't follow the correct procedure in removing Advocate Ngasana.
I accept that.
But then why, Advocate Batohi, why are you talking about his credibility when you have no evidence that there was a problem with his credibility?
I said it was perceptions. His credibility has a bad perception at that point.
But you are a lawyer.
Mm-hmm.
You are an advocate of the High Court. You know you cannot make decisions on perception. You have to make decisions on fact.
I didn't make any decision.
But then why are you scandalizing his name like this?
I didn't scandalize his name.
When you say a lawyer, an advocate, has a bad perception of their credibility, that's not scandalizing them.
Well, it was in a closed meeting. I didn't expect this to be out in the public because that was...
So you can scandalize a man with no evidence in a closed meeting?
No, I'm not saying that. I'm not saying I scandalized in the first place. It was just that there was a perception about his credibility, and I mentioned it.
And in fact, it goes further because you do really factor this in. You say, this also calls into question about what an NDPP must see. If we get a bad decision, that will impact not just on me, but all future NDPPs in making authorization. A bad decision and the perceptions could really have a bad impact on the NDPP. I spoke to Adv Chauke and I said, I want 3 senior people to look at this case. Now we can do that. I don't want to look like I'm just overturning Sean's decision. I'm thinking today I'm open to reviewing it. I asked Tory how long it will take to review it. He said 2 months. I don't have 2 months. Again, here you refer to this question of the perception, and you say you don't want people to just think you're overturning Sean's decisions, Mr. Abraham's decisions. And it seems to me for you to deny that this idea of the perception played a role in your thinking is false, because it carries through. You had this perception and you wanted to do something about this perception.
Perceptions had nothing to do with any of my decisions. I do not make decisions on perceptions. I make decisions on evidence, because the rule of law is really important to me. And so if we look at the transcript, it says this also calls into question about what an NDPP must see. I don't talk like that. So I don't even know what it means. If we get a bad decision, that will impact not just on me, but on future NDPP making authorizations. Clearly there, I was trying to make the point that we need to do this properly. So there's the gist of it, I get is what we were talking about. But to put an emphasis on each one of the words when it's clearly a transcript that might not be accurate, I think I have an issue with that.
Well, I think that is fine. But I think on this particular issue of the negative perception of the credibility of Mr. Abrahams, you've admitted it. And you even stated that you thought it was a closed meeting.
It had nothing to do with my decisions at all. My decisions were based only on the evidence, because I respect the rule of law.
And if you turn over the page to 338, there's something I want to ask you about this page. The third line, which starts with SB, it says the victims don't get justice because of the way the charges are couched. That is you stating.
If it's accurately captured.
Yes. But what I'm interested in is the response you're getting from Mr. Epstein. Now remember, Mr. Epstein has already given you a memorandum. He says it's not worth the effort since people can still get justice. And then he says, obviously you shouldn't issue poker certificates unless capable of successful prosecution. And look at what he says next. Lekhodi said he had enough. Now we know which Lekhodi he's talking about. It's Judge Lekhodi, which is referenced in his memorandum. And then he continues, prosecutors believed that there was. Sean, that's Advocate Abrahams, is given a presentation, which is JB 27. He then gets Danicus's supplemented statement, and he looks at what is on the flash drives, and then he issues. You are right, it must be a rational decision. You can just review. We think it's a valid reason to say it's in the public interest. Give proper reasons. And then Hilton Epstein takes SB, that is Advocate Shamila Batohi, through his presentation. There are three things that are clear here. What Mr. Epstein is telling you is that Judge Lekhodi said there was enough in relation to the Advocate Jiba decision to charge. Your own prosecutors believed that there was enough. Mr. Abrahams believed there was enough. Is that correct?
That's what he says.
Yes.
If it's accurate.
Well, Advocate Hilton Epstein had given you a memorandum. This is perfectly consistent with that memorandum.
The prosecutor's memorandum.
No, his own memorandum that we started with this morning.
Can you refer me to that again, please?
At page 254.
So your question again is, Counsel?
I'm saying that what he's saying here, the summary, is perfectly compatible with the written document that he gave you in preparation for that meeting, where he explained that Judge Lekhodi said there was enough, the prosecutors believed there was enough, Mr. Abrahams believed there was enough.
Yeah, I'm not sure if he specifically mentions Judge Lekhodi in his memorandum. His memorandum sets out the principles of issuing poker. He then goes into the case against General Boyson. I'm just trying to see what the purpose of the memorandum was.
No, the Lekhodi J, I thought we had looked at it earlier, appears at page 269, which is part of the documents that were sent to you.
Yes, it's not part of the memorandum on 254.
Yes, but it is an attachment to the email that he sent you.
Yes, that's right. It appears in this document,
Yes.
which is an attachment.
I will come back then to where we were. I still make the point at page 338 that that summary that he gives is compatible with the views that he had expressed either in a memorandum or by way of the attachments to his email. He's just repeating it verbally.
Well, the attachment to the memorandum that you referred me to now, where the Lekhodi decision is mentioned, is an extract from Advocate Abraham's affidavit.
Correct.
Yes, so he attaches Advocate Abraham's affidavit, and Advocate Abraham's views on the Lekhodi judgment are incorporated there.
Yes.
So on that basis, sorry, I'm trying to keep a lot of pages open here. I'm trying to answer your question
Well,
carefully and properly. Sorry, can you repeat that question to me? And I'm going
saying
to write
that-
it down now so that I'm
saying there are 3 points that come clear from what is being said by Advocate Epstein. The first is he is reiterating that Judge Lekhodi said there was enough to issue the poker certificates. Number 2, your own prosecutors said there was enough to issue the poker certificates. Number 3, Mr. Abrahams also believed there was enough after looking at the statement of Mr. Danikas, looking at the flash drives, and then he issued. Now, those 3 are clear, and they are all consistent with the material he had given you beforehand.
That was his view,
Yes.
and he, although he said Lekhodi as it is here, Judge Lekhodi said he had enough.
Yes.
That's his view. I haven't been asked about the Lekhodi decision, so I won't comment on that now. But this is what he said, and to that extent, that is correct. That's what he said.
Yes. Now, this is why this is important, this part. This is the senior counsel that is acting for the NPA in defending the application brought by General Boyson. Is that correct?
He was acting for the NPA
Yes.
in defending the application.
Yes. But Advocate Batohi, there is no question that his opinion expressed verbally to you was that these are the basis on which this case can be defended. And he explained where they come from.
His explanation of where it came from was from the prosecutor's memorandum. He says the prosecutors believed that there was, and also from Advocate Abraham's affidavit. So he based his view on those two things.
Well, also on the judgments. On the princely judgment, it's a whole lot of things we've just looked at.
That's correct.
This is what I don't understand, honestly. You have a senior counsel that is acting for the NPA. He gives you full authorities and comes verbally to justify the decision. You override them.
All I say is that I want a team to look at all of the evidence. And of course, that team may have come back saying exactly what, or supporting what Advocate Epstein had said, and that would have been fine. But I wanted a team to look at all of the evidence in these matters so that I could get a proper opinion based on all of the evidence, not only on the prosecutor's memo, the prosecutors who took the decision, the impugned decision, as well as the NDPP, who also took the impugned decision.
And moreover,
At that time, I beg your pardon, sir. At that time, Advocate Batohi, had you yourself, as the head, had an opportunity to peruse the evidence?
No, I didn't.
Did you make any effort whatsoever to
I
make
didn't.
time to look at the evidence?
No, that was the purpose of appointing the panel.
Now, I'm talking about yourself as a head. It's one thing to rely on what other people are saying, but had you made time or set time aside yourself to read the evidence that was presented or what that was going to be presented to the team?
Chairperson, I was barely 2 months in office. I thought that the best course of action in these circumstances would be to appoint a very experienced panel to look at all of the evidence in this matter. And that is what I did. I believed it to be the best course of action in the circumstances.
now,
And
sorry.
that team, the experienced team that you had in mind, would have included the Advocate Chauke's team.
That's correct.
And who else?
It was Advocate Chauke, who was at the time the DPP in the Western Cape, Advocate Ivy Tenga, who is currently the DPP in Limpopo. I think she might have been the DPP Limpopo at that. She was certainly a DPP, but in which division, I'm not very sure at that time. Advocate Riley, who is a deputy DPP in the office of the DPP Western Cape in charge of the organized crime component, and Advocate Mamabolo, who was at the time at the NPA head office at the racketeering desk.
And these people constituted what we refer to as the Chauke team.
That is correct, Chairperson.
Now, apart from the Chauke team's memorandum, whose memoranda did you rely on?
In making the decision in this matter,
Yes, of course.
I relied on the Chauke team memorandum.
But we've just spoken about the first, the Chauke team's memorandum.
Mm-hmm.
You relied upon their recommendation.
I did.
Now, my question is, who else did you appoint to look into the evidence? Who else did you appoint to look at the evidence subsequent to the Chauke team?
So the purpose of the de Kock panel report was to decide on the approach in these proceedings. Subsequent to that, I obtained the opinion of, and to be clear, Chairperson, if I may clarify.
Yes, you may, ma'am.
Thank you very much. To be clear, Advocate de Kock's team was not looking at the conduct of any members of the NPA. They were looking only at the merits of the racketeering prosecution for the purpose of me deciding on the approach in those proceedings. So they were not looking into the conduct of any particular member of the NPA. That was their mandate, is to consider the evidence and advise on those review proceedings. Subsequent to that, the other opinions that I obtained specifically dealt with the conduct of Advocate Chauke, and that was Advocate Nalane, thereafter, Advocate Chauke then got a response to that and provided Advocate Maineche's opinion. And then it was the de Kock memorandum that forwarded me Advocate Maineche's opinion, where he also expressed a view. And then it was, well, your question, Chairperson, was the opinions that I sought. So the ones that I sought, to be clear, are the Nalane one, the one from Dr. Broughton, and the one from Advocates Hully and Wenzel.
With regard to the conduct, the impugned conduct, if I may put it that way, the opinions that you sought were those of Advocate Nalani,
Correct?
followed by that of de Kock, Advocate de Kock.
No, that was not an opinion I sought, Chairperson.
That is the one that was responding to Advocate Maineche's opinion.
Yes, it was his memorandum forwarding me Advocate Maineche's opinion and where he expressed a view.
Yes, I'm talking about that.
Yes.
And then after that, Dr. Broughton's opinion.
Correct?
Specifically on what?
Dr. Broughton's opinion was specifically on the Boyson matter. I should look at my affidavit just to make sure that I'm certain about that, Chairperson.
But maybe to be specific, let me be fair to you. As regards the conduct, the impugned conduct of Advocate Chauke,
That is correct.
and thereafter you sought an opinion from Advocate Helly, but only in respect of the Mdluli matter.
Yes, Advocates Hully and Wenzel.
Yes. I'm sorry, Council, I just needed to get the
Indeed.
sequence and what
Yes.
was relevant that time.
Yes,
Thank you.
indeed. Now, at the bottom of page 338, you comment again, Advocate Batohi. You say, can you give me an opinion on those lines? Even if there is sufficient to charge, but on the basis of what you have just said, victims will still get justice. This case is strategically not worth fighting. Can you explain what did you mean that the Major General Boyson case is strategically not worth fighting? What is the strategy?
I'm not even sure that I said that. I don't know. I can't answer it because I would not have at that point. I did not make a decision on whether we should oppose that matter or not. So this is actually incorrect.
See, this is the second time you are referring to strategically. You started at page 337. in the fourth line, where you said, on the one hand, I get a sense that with the murkiness, if the victims get justice strategically, this case, and then the sentence is incomplete. I then said to you, there is another place where you complete what you mean by strategically, which is at page 338 at the bottom, where you say, this case is strategically not worth fighting. Your answer is, you believe this portion of the transcript is wrong because
My point, sorry.
you believe this portion of the transcript is wrong because you would not have used the word strategically not worth fighting.
No, all I'm saying is that the fact that I may have used the word strategic earlier on and then later on use it again does not mean that logically I was referring to the same thing. I cannot recall what I was talking about at the time and in what context. I mean, a national director must think about strategic issues, but in this case, I needed to deal with the evidence in the matter and take a decision after that. If you look at the portion that you have just quoted from at 338 at the bottom, Chairperson, it says, can you give me an opinion on those lines? I don't even know what lines is being referred to there. Even if there is sufficient to charge, but on the basis of what you have just said, it ends there. And that sentence doesn't make sense as it is. Then it says, victims will still get justice. This case is strategically not worth fighting this. I have no idea what the point is. It just doesn't make sense to me because I would not make a decision. I did not make a decision at that point, and I will not make a decision on matters like this without properly understanding what the essence of the case is and the evidence. And that is what I did. I immediately followed to say, I really do need 3 people to review this case. Then I don't need to. And that's the end of that sentence as well. I don't know what that means. I don't need to do what. It's just not clear.
Yes. We'll come back to that.
Just for my own clarity, this seemed to be minutes of a meeting that was held with the people listed at page 334
That's correct?
on 6 March 2019.
That is correct, Chairperson.
You were present at that meeting.
I was.
Did you get a copy of the minutes of that meeting afterwards?
I can't recall having received this, Chairperson.
Did you not ask for the copy of the minutes?
No, I didn't. I had Donnie Smith, if you look at 335 at the top, who was also in attendance. He was my chief of staff at the time. He's no longer in office. He and also Advocate Matska, Trish Matska, who's also, she was a deputy DPP in the office at the time. And they would have taken notes because normally I have colleagues in meetings to take notes. Advocate Matska left the office and we don't have any of her notes. Advocate Smith has also left the office and we don't have any of his notes. But I imagine that either one of them would have taken, so we didn't ask for any minutes.
Yes.
I asked the question because your answers seem to challenge the authenticity of these minutes. Most of your answers.
Yes, that's correct.
That's why I'm asking the question, that you have a meeting with senior advocates regarding these important matters, and nobody takes minutes.
That's not what I said, Chairperson.
What are you saying?
I said that Donnie Smith and Trish Matska would have taken minutes of this meeting. They would have made notes of the meeting because it's important that we keep a record of this. And that is why I have staff members in my meetings to make sure that they do take notes of meetings. Advocate Matska has left, and I know she none of her notes are available. I wasn't aware of when this meeting happened. My office has been trying to get the dates of these meetings, and I've asked them to try to get notes and minutes of the meetings because it's important that I have it for these purposes. But up until now, we haven't been able to trace these matters. So we will keep looking, Chairperson.
Yes, but my concern, Advocate Batohi, is that as the head of the NPA, who has just attended a meeting with senior counsel, at least on the 7th of March, the following day, or a few days thereafter, for your own recording, for your own record keeping, I would imagine that you would have asked for the recorder of the interactions or the discussions at that meeting.
Chairperson, if I may, I don't always do that. I expect that my team will keep the record of these meetings carefully for future use. And that's the way, we deal with these issues, is someone takes notes and they are meant to be properly filed so that we have them for future. But if I have formal meetings like EXCO and MANCO, etc., I then insist we get minutes immediately after that. I check them very, very carefully because they must be an accurate record of the meetings, and then they are dealt with in that way. So with formal meetings, we do, but I'm not saying this wasn't an important meeting. It was, and we would have a note of this meeting, but at this point in time, I'm not able to find it.
Proceed, Councillor.
Advocate Batohi, were you not trying to hide this meeting? Were you not concerned that this meeting should never be known, and this is why it was not recorded?
Absolutely not.
Were you
I
not?
had no reason to hide this meeting.
Well, this is what I don't understand. If you had no reason to hide this meeting, why don't you invite your own prosecutors that were involved in this matter?
It wasn't hiding it from them. I invited those people that were relevant, that I thought relevant at the time.
Well, the most relevant stakeholder is the party that is doing the prosecution.
At that point, we weren't discussing the merits of the prosecution. We were talking about the review application.
So the review application is a review against the prosecution.
That is correct.
That's what I'm asking. You were trying to hide it from them. You didn't want anyone other than those who were in the meeting to know about it.
How can I hide it when there are external people there. They can talk about it. It was not a secret meeting.
Well, you understood it to be a secret meeting with only those who attended.
No, I didn't say it was secret.
Can you go to page 346? The second line, where you say, I would prefer that none of this gets out. And Mr. Epstein's response, can I suggest this? Even that other people are being brought in, the only thing to be said is that an approach has been made to the NDPP and she's considering it. It seems to have been explicit that you were trying to hide this meeting.
I was not trying to hide it. If you look at it further, context is everything. It's about the media, and this was a very high-profile matter, and I did not want it to get out into the media. If you look further down, I say I've stayed out of the media, again, on the assumption that this is, accurate. I've stayed out of the media, so I'm talking about the media, and things, in fact, if you look at page 345 at the bottom, we were discussing the context of timelines, it appears, if you look at that. And it was, when should we meet again? How long will we take to have a decision? And then they were asking, if you look at the bottom, Advocate Katz says, can I tell him in a month you will be in a position to advise on the way forward? I'm not sure who he was talking about. Tell him. It's probably Boyson. I'm not sure. I'm assuming. And then I say things get out in the public and the media makes a meal of it. I would prefer that none of this gets out. So I didn't want it to get out in the media that we were having conversations about this. But this was not a secret meeting.
Well, you also didn't want it to get out to your own prosecutors. You never, ever told them about this meeting up until today.
That's correct.
Now, that's the real reason why no one took minutes, and we were only assisted by the team of Advocate Hilton Epstein that was prudent enough to take minutes. You simply didn't want this meeting to be known.
That's totally untrue.
I beg your pardon?
I say that is totally untrue.
Just one thing. Advocate Batohi, how often would you have meetings similar to that one, where there would be no record of the minutes of the meeting?
I always have somebody in the meeting to take notes. And I suppose it's only, sorry, I only have, I generally, unless it's a one-on-one meeting for any particular reason, I generally have someone in the office present taking notes, because it's important that we have a record of these meetings. It's only if at some point we're looking for the record and we can't find it that I realize that there's some filing issues in my office that I need to look at, and it's not acceptable at all, because the record of these meetings must be properly kept for future reference. So I certainly don't have meetings where there's no one taking some notes of the meeting.
Yeah, what steps would you take to ensure that whatever is minuted can be relied upon as an authentic and accurate record of what happened at meetings?
I generally don't look at the notes immediately after the meeting. I expect that my team and that if we need it at a future stage.
The question is, what steps would you take to ensure that the document that has produced either as a report or a minutes of the meeting is the accurate record of the meeting that has been held? And maybe I must tell you why I'm asking you this question. Well, much as we are told that this record that we are being referred to now, it's a minutes of the meeting that was held on the 6th day of March 2019. But when one goes through this document and you have been saying it again and again, I'm not sure whether this is an accurate reflection. I don't know whether this is what happened. But if it's an accurate reflection, then this is the answer. Ultimately, we're going to remain with unanswered questions, because all of them, either they are premised with an if it is correct or I don't know. So hence the question, what do you do in your office? What steps do you take to ensure that? And it's not only for your benefit as a person who's an officer there, but even for the benefit of your successors. What do you do? What steps do you do to make sure that whoever finds documents in your office as a record of what happened at meetings is a real correct and accurate document. It's not just a document that one can come across and see this is one of them. What steps do you do to avoid the situation where we find ourselves in now? That in everyone, it's I don't know, but if, do you understand my question?
I understand your
Please
question
answer
well.
the question that I've asked them. Thank you.
So, as I said, with regard to formal meetings, there are minutes that are taken. These are circulated after the meeting. I personally check and make sure that they are accurate. Members, it's circulated to all those that attend the meeting. And I make sure, and my team knows, I say to them, these are formal meeting minutes that must be accurate because it is a record for posterity, for whoever needs it. I will call this an informal meeting. Meetings like this, I have someone from my office taking notes. They are professionals, and I expect that they will take the notes properly, and there will be a record of it for the future. I do not check those notes.
Put otherwise, do you perhaps initial each page? That's one of the easiest way of making sure that even your successor will know that Batohi was here.
I do not do that.
You do not do that.
No.
It's just it's documents that appear like this one.
No, this is not my document.
No, I know it's not, but it appears like this. There's nothing that shows that, and that gives you the comfort that this is a fair reflection of what happened at the meeting.
With informal meetings, I do not check them.
Thank you.
Yes. Now, at the bottom of page 339, you welcome Mr. Carl van der Merwe and Mr. Anton Katz. You say to them, this is a case with a long history. I have only been here for a month. I'm trying to get to a point where we can focus on what we should be doing. I'm trying to clear the air. As a civilian in the Netherlands, the NPA is tainted. This is the second time you are condemning the organization as tainted, even though you admit having been there only for a month. Is that correct?
I have never condemned the NPA as tainted. I've always said that there were certain people in the NPA that are tainted, and the majority of the prosecutors in the NPA are hardworking and dedicated to the rule of law.
Yes, according to this note.
But there was a credibility deficit at the time. Sorry.
Yes, according to this note, the references are clear that the NPA is tainted.
The NPA was definitely facing a credibility crisis at the time because of the actions of a few, or alleged actions of a few, I should say.
Advocate Batohi, we've been through this and have tried to give you a fair chance to produce the evidence. And the best you could do is to refer us to perceptions. And then you invite Mr. Katz to present his proposal. What proposal were you inviting?
I wasn't inviting any proposal. I had my counsel there and the state attorney, and it was a meeting to hear what they had to say.
Well, it's strange you are saying you are not inviting a proposal, because the sentence says, I know Hilton has spoken to you, and we've seen Mr. Epstein started the meeting by telling you that he spoke to Mr. Katz. And then he says, but I would like to hear your proposals. So you are clearly inviting a proposal from Mr. Katz.
We are using these notes to cast my mind back to the time and try to understand what happened. On the basis of this, it appears that counsel were talking. Epstein and Katz were talking. And so we decided to meet so that I am there as well, because at the end of the day, I have to decide on the way forward. So that's what happened. And yes, if they had proposals, then they had proposals.
Then Mr. Katz explains that he has met with his attorney and does not give a specific proposal. But
Where
then
is
you
that?
say in the next line, but then you intervene and you say the families must be seen to have justice done. Again, this is the second time you are referring to perception that the families must be seen to have justice done. Can you explain how would the families get justice by withdrawing the case?
As I mentioned, it is really important. It doesn't matter who is involved in the case, whether it's General Boyson, who might be an angel or might be an ogre, I don't know. It's important as prosecutors, we represent the victims of crime, and justice for the victims is really important. In this case, justice for the victims could either be by way of racketeering charges, if they were justified, or they would be with regard to prosecutions in any of the individual cases, if there was evidence to support a prosecution. That would be justice for the victims, either one of those options.
Just explain my question. How would justice be achieved by withdrawing the case? Because we know both the racketeering charge was withdrawn and the predicate offenses were withdrawn. Just explain how would the families get justice out of those withdrawals?
Families and victims can only get justice where there's evidence to support a prosecution. In this case, after I withdrew the racketeering charges, I referred all of the dockets to the DPP KZN and asked her to look at each one of them and to decide whether there was evidence to prosecute any of the accused in the matter. And of course, if there's evidence, we will prosecute. There are many cases where families don't see justice done because there is no evidence, and we cannot prosecute if there's no evidence.
So are you going to answer the question, how would families get justice by withdrawing the cases?
They would get justice if there's evidence and the case is proceeded.
All right, I will leave it then on the basis that you won't answer the question.
I did answer the question.
All right. Perhaps I should ask it once more. How would the families get justice by withdrawing the cases?
My point is that justice for families and victims means that in some instances, justice means different things to different victims. But one of them is prosecutions. And we must only prosecute. And we have to explain to victims sometimes where there's not enough evidence that we simply cannot prosecute the matter. And in those instances, sadly, families don't see justice.
Yes.
But we cannot prosecute a case simply because we feel that we want to bring justice to families where we do not have the evidence to support a prosecution. We will never do that.
Yes. Now, we will deal with the evidence at a later stage. But I want to understand whether your answer to this question is that this is one of those cases where you admit that the families never saw justice.
In this case, I'm trying to think about this carefully because if there's, let me think about how I frame this. In cases where crimes are committed, there are victims, and as law enforcement, we must try to ensure that there's justice. But we can only do that when there's evidence. In this case, it was apparent from the decision of the DPP as well that there was no evidence to sustain a prosecution in any of these matters. So to the extent that there were crimes committed, yes, the families in this matter did not receive justice.
Thank you very much. I want to then turn to the to page 343. It's 2 pages later. In the third column, Mr. Katz says, we come here, I wouldn't want to put obstacles. Our instruction is that there won't be a section 179.5D, but there may be some on the docket. There was nothing to pin the 5 predicates.
Sorry, I'm not in the right place. Where are
It's
you?
page 343.
All right.
And then in the third column,
I'm there.
where Mr. Katz says, we come here, I wouldn't want to put obstacles. Our instruction is that there won't be a section 179.5D, but there may be some on the docket. There was nothing to pin the 5 predicates. He's talking about Major General Boysen. The Howick events, there is just nothing. It is something that you would have to consider in the fullness of time. I wouldn't want Boysen to go through a full trial, and then he claims malicious prosecution. What is clear here is that you've invited the advocates for Major General Boysen, and they are dictating the terms, and there is no apparent resistance from you.
May I comment on that?
Yes.
They were certainly not dictating any terms in that meeting. Of course, I cannot stop them from saying what they want to in a meeting, but there is no way they were dictating any terms at that meeting. And I don't, whether, as I keep saying, I don't know how accurate this is, but even if I just listened and didn't say anything, it doesn't mean there's no opposition from me or that I'm simply accepting what they're saying. I'm just listening.
Now, they specifically say, and we know that there are 5 predicate offenses against Major General Boysen. They say there is nothing on the 5 predicates. This is why I asked you, why did you not invite the prosecution team? What you have managed to do is to enable yourself to receive a one-sided account by counsel for the accused.
I had my counsel there as well, Advocate Epstein. And so I was not making any decisions on the merits of this matter. They could say what they want to. So that is an incorrect assumption on your part.
Did you believe that there was nothing on the 5 predicate offenses, as they said here?
At that point, I had no idea.
Were you concerned about the risk of malicious prosecution?
I am always concerned about the risk of malicious prosecution.
He specifically refers to the docket containing information about the 5 predicate offenses. We know from the cross-examination on Monday that you never considered each of those dockets. I just want to ask you not whether you did or didn't, but why not, especially where there is a lawyer that says there is nothing to pin those offenses on Major General Boysen? Why don't you say, let me read these dockets myself?
In my view, getting a very experienced panel to do that was the appropriate course of action, and I did that. I gave them sufficient time to look at all of the evidence and give me a report.
I don't think you're answering my question. Why don't you, as the NDPP, ask for these 5 dockets that are referenced by counsel for Major General Boysen and say, I want to read it? For me, it strikes me as a dereliction of duty on your part.
With all due respect, as you quoted from Advocate Epstein earlier on, it's not expected of a national director to look at all the evidence. But what is expected of you is that you take all reasonable steps to understand the evidence and to get a good, proper opinion on things. And in my view, that was the best course of action here. It did not require me to look at all of the dockets myself.
On the 6th of March, 2019, had you had a sight of any evidence on
Of-
the 6th of any evidence on the 6th of March?
No, I don't think so. I wouldn't have.
You wouldn't have. It's page 338, the last block, where you say victims will still get justice. This case is strategically not worth fighting. What do you mean there? This case is strategically not worth fighting?
Chairperson, I do not know if I said that, because if you look at my very next sentence, it says, then, oh, well, hang on. I say, then do I really need 3 people to review the case? Then later on, having listened and considered more, in fact, and we must understand, Chairperson, that there's 2 parts to this transcript. The first part is when Advocate Katz and Van der Merwe, Carl van der Merwe are not present. So this part that you are now referring to,
I don't know.
that is
When
from,
were they present? When were they not present?
yes,
I'm
Chair,
just referring you to that portion because it seems certain lines are correct of these minutes and others are not correct. So are we now going to go through the minutes and determine which were correct and which part of the minutes were not correct?
Chairperson, that's impossible 7 years after the event. I have no idea what is correct and what is not correct. I'm trying my best to answer the questions on the basis of what is recorded here, but I have no idea. And to deal with your first point, Chairperson, if you look at the entire transcript, the Boyson matter starts on page 336. Well, I'm not so sure. Ignore that, Chairperson. If you look at page 339, at the bottom, I welcome Carl and Anton. So my assumption then is, because I also couldn't recall, but on the basis of that what happened prior to that, because we also discussed other matters, is with my counsel, Epstein, and others from my office, and that at that point, at the bottom of 339, is where counsel for Mr. Boyson, General Boyson, joined the meeting. So what the chairperson referred to now was something that was before they had come into the meeting.
Yes, but let's look at the content of 339 that we have just referred to, and then go back to my question, where you say this is a case with a long history. And I suppose the same case is the one that you speak about at 338, the last block, correct? I just want to
I'm not sure,
I
Chairperson.
just want to ascertain from you, which case are you referring to at 338 and 339?
Chairperson, I'm trying to ascertain that from the record that we have before us. If you look at the lines above the portion that you have just read out, it says, elaborates on Madhu prosecution proceeding and mentions that Pandey is an accused in the matter. We can get an early date, but we may lose. Then can you give me an opinion on those lines? So if you look at the context again, I am not sure. It appears it could be on the Pandey matter because Advocate Epstein was also involved in that matter. There was another review application there. So I don't know which one is being referred to.
In both instances, at 338 and 339?
At 338, I'm not sure. At 339, At 339, it will definitely be the Boyson matter. At the bottom, are you referring to the block right at the bottom, Chairperson?
Yes, madam.
That will be the Boyson matter because counsel and the attorney had joined the meeting.
And the one at 338 could have been the Pandey matter, you said?
It could have been, or it could have been the Boyson matter, I'm not sure. In fact, the Pandey matter was, well, it's not necessary for me to explain that, Chairperson.
On the top of 338, I'm just going back to that because council was proceeding ahead and I don't want to forget clarity on these points. 338, the third block. The victims don't get justice because of the way the charges are couched. You earlier on spoke about the evidence. Is it because of the evidence availed or because of the way the charges are couched? What was important?
I don't know, and I don't even know again whether that's exactly what I said. The victims don't get justice because of the way the charges are couched. Doesn't make sense to me, so I'm not sure. Because Mr. Epstein, Advocate Epstein, just before that talks about a fraud example. I mentioned to him, I'm just trying to get the context to try to answer your question, Chairperson. I mentioned to him before counsel for Boyson joins the meeting at the bottom of 337. I spoke to Rodney de Kock and I said I want 3 senior people to look at the case. And so we seem to be dealing with that matter. And then he says, we spoke about this.
Which matter?
The Boyson matter. At the bottom of 337, I spoke to Rodney de Kock and I said I want 3 senior people to look at the case. Now we can do that. I don't want to look like I'm just overturning Sean's decision. I'm thinking today, I'm open to reviewing it. I asked Tory how long it would take to review it. He said 2 months. I don't have 2 months. And then Advocate Epstein says we spoke about this and gave fraud example. So I don't know because there are no fraud, not that I'm aware of any fraud charges in the Boyson matter. But there may have been in the Pandey matter. So that is why I'm confused about what I apparently said about victims don't get justice because of the way the charges are couched, what it refers to at all, which case. It's very confusing to me as well.
Assuming it refers to the Boyson's matter, or the evidence have not been more critical than the manner in which the charges were fashioned or couched.
And also on the assumption that I said those words, Chairperson. I'm trying to assume that it is in respect of the Boyson matter and assume that I said that. The victims don't get justice because of the way the charges are couched.
I see the 2 senior counsels are conferencing over there. Is getting into the mic. You're having a discussion. Yes, thank you. Please answer. Proceed, madam.
Chairperson, I'm thinking that justice for victims is a prosecution for is a prosecution, and how we actually frame the charges is up to the prosecutor. And so justice isn't dependent on the way a charge is couched. It's about the prosecutor deciding on the correct charges, and at the end of the day, justice for the victims will be if there's a conviction in the matter. I'm trying my best to explain this.
On the correct charges or on the evidence that is to be presented in support of the charge? Or am I getting it wrong?
Chairperson, yes, I would always, in my view, there should never be a charge if there's no evidence. So it would be on the basis of the evidence that is presented.
Thank you.
Advocate Batohi, we are still at page 343 on the question of your failure to satisfy yourself by a reference to the dockets about whether or not the claims that were made on behalf of Major General Boysen were accurate. And you've said there are certain cases that say an NDPP does not need to read the docket. But the importance of the docket is placed squarely by the NDPP itself in the opinion, by the NPA itself, in the opinion of Dr. Broughton of the 21st of April, 2023, which appears at LO 00171, volume 1, Madam Chair. So it's volume 1, LO 00171. That's where the opinion starts.
If I may take you back, in relation to which part of 343, by the way?
It's in relation to the
last
1, 2, 3. Yes, the third block.
The third block.
Yes.
8K.
Where it is claimed that there is nothing on the docket.
Sorry, Chairperson, if I could just be on the same page, at page 343.
Yes, at page 343, Mr. Anton Katz claimed that there was nothing on the docket against Major General Boysen on the 5 predicate offenses.
Yes, I see that.
Now, we then debated the centrality of any decision maker to withdraw those charges having regard to the docket. Now, I'm putting to you that it's the NPA itself that says that prosecutorial decisions must be based on the docket. If you go to LO 00187.
If you could just slow down a little bit, I'm trying to make notes at the same time. Thank you, Counsel.
LO
00187.
87.
Yes. At paragraph 51. Now, there the judgment of Miller J. in Porritt and another versus NPA is cited, and the underlying portion is clear. The decision to prosecute or not is made on the entirety of the contents of the docket and hinges essentially upon the question of whether the person in respect of whom the complaint is made can be successfully prosecuted. Now, you've been extolling the virtue of this opinion. I presume you accept what is stated at paragraph 51 and the case of Porritt that is cited there.
I do accept that.
Yes. Now, your own decision to test whether it was correct that there was nothing on the docket would have required you to study the dockets.
Should I comment on that? Are you done, Council?
Yes, I am.
So, firstly, if you bear with me, Chairperson, I just want to get my thoughts together.
You may.
I'm just trying to find Advocate Epstein's memorandum that deals with this aspect, as that is pertinent in this regard as well. If you bear with me, Chairperson. So at page 255, although Advocate Epstein does not cite any authorities, there are certainly sufficient authorities. Let me just go before that, Chairperson, if you'll bear with me. If you start at 254, where he cites State versus Chow and others, at paragraph 2, he quotes from there and deals with the extent to which every document must be considered before issuing a POCA certificate. And quoting from that decision, may I read it, Chairperson?
Yes, you may read now.
In requiring that the NDPP apply his mind in issuing a Section 2(4) authorization, it is by no means logical, necessary, or practical to require the NDPP to read the contents of an entire docket before making a decision whether to authorize charges under POCA. Requiring so would render the issuing of Section 2(4) authorizations a time-consuming exercise. The operational requirements of the state must be balanced against the interests of the affected parties, as, and he quotes, a measure of proportionality must be adopted in the evaluation of the interests of the affected party and the burdens placed on the decision maker to arrive at a reasonable decision, close quotes. And that's from paragraph 34 of the cited case. And then Advocate Epstein states at page 255, paragraph 1, this is consistent with the wealth of authority, affirming that decision makers are entitled to rely upon summaries of underlying material prepared for them by their subordinates who are well versed in the matter and whose judgment the ultimate decision maker is entitled to trust. Now, bearing that in mind and then answering Advocate Ngcukaitobi's question, firstly, I agree completely, and we are not saying different things when I say that a decision to prosecute must be made on the contents, the entirety of the contents of a docket. But it does not require that the National Director, him or herself, read the contents of all dockets in a particular matter, a docket or dockets. In this particular case, it was completely reasonable for me to have appointed an experienced and skilled panel to look into all of the evidence, meaning the evidence in all of the dockets, which they did, and provide me with an opinion. So what was done here was consistent with all the case law that requires prosecutors to make decisions on the basis of the contents of a docket, and where it's clear a National Director is not expected to read the entirety of dockets before he or she comes to a decision in a matter. Thank you, Chairperson.
Does it mean that the NDPP, even if he or she does not read the entirety of the record, he or she should not even peruse the dockets, not necessarily in their entirety?
That is my understanding. That is my understanding of what it means, Chairperson.
What?
That is my understanding of what it means.
Meaning that you need not read, you may not at all read the dockets.
The entire contents of a docket. That is my understanding of what it means. And you're entitled to rely on experts in your office who must do that, who must read the contents of all the relevant dockets.
So if my understanding of your answer, after reading that passage, you understand it to mean that you need not read the dockets at all yourself as the head.
That is correct, Chairperson.
Thank you.
May I just come in here? I'm taking you back to the issue of not inviting the prosecution team to discuss this case of racketeering. Because I'm trying to understand your rationale for taking this approach, especially regard being held to the fact that, firstly, you had not read the case dockets, and as a result, you bore no personal knowledge of what informed the prosecution team to act in the manner that it did. And secondly, because at this meeting or any other meeting that you would have called, you had the benefit of the SC who would give advice. In particular, in this case, it's Advocate Epstein. Why did you not find it fit to at least put the prosecution team that has full knowledge of the dockets and Advocate Epstein in the same room so that an intelligent discussion can be held between parties as almost equals about the understanding of this matter of racketeering?
It was never my intention to discuss the merits of this matter at that meeting. That is, what the evidence was, who is right, who is wrong. That was never my intention. So it was never going to become a meeting where one side was going to say, this is the evidence, the other side is going to say, this is not the evidence. That was not the purpose of the meeting. So I didn't think that it was necessary for the prosecution team to be there.
Yeah, I'm saying, looking at the fact that you yourself knew nothing about the dockets and so forth. And I'm not proposing a meeting where even Bokets and them would participate. It's not one side against the other. It's one team. It's the advisor, the SC, Epstein, as well as the prosecution team working together. I would never just think of a time where you can put the two opposing parties together and to make them then discuss as you did. My question is based on maybe an expectation from my side that regard being had and taking cognizance of the fact that you knew nothing about the dockets, these dockets in particular, the people that knew about the dockets, it's the prosecutorial team. And I think to an extent, Advocate Epstein, who would also enlighten and be enlightened in the discussions around this. Thank you.
So, firstly, I thought you were referring to the meeting of the 6th of May. Is that not correct? Are you referring to something else?
The meeting
clarity.
the meeting of March From
Was
the
it
way I
March
read,
6th,
yeah,
yes.
the March 2019, the way I read the record has not been put in dispute as the fair record of that meeting. Seem to see an indication that there was a time when it was the team of the Boysons team was not available yet. They arrived later.
Mhm.
So at the time, you could have actually you had the opportunity to have the private discussion where the prosecution team, as well as Advocate Epstein and yourself, would be sitting together in order to get, for the benefit of the NPA. That exercise would have been undertaken for the benefit of the NPA more than for any other person in particular in his or her personal capacity.
So at that point, I was engaging with Advocate Epstein only. And he was giving me, given that this was the review proceedings, he was giving me briefings, etc. I did not engage with the prosecution in this, the team in this matter. I think at that point, I did have concerns about whether they had acted properly in the matter already. So I thought I needed to have a process whereby I could come to an objective understanding of what exactly happened in this matter and what the strength of the case is. So at that point, I didn't see it necessary to speak to the team. I only spoke to Advocate Epstein. I had also discussed the matter with Advocate Chauke prior to this meeting. And you will note and the only reason that I know that is because there's reference in this minutes to me having spoken to Advocate Chauke prior to that. So at that point, I didn't think it was necessary for me to speak to the team. But there's one, that's my answer to that part of it. But there's one other aspect of your question that I want to make sure, I'm not sure if I heard it properly. I thought I heard you say it's not been put in dispute. This record has not been put in dispute as a fair record of the meeting, because it is in dispute as a fair record, as an accurate record of that meeting. So I may have misheard you, I'm not sure. I just wanted to clarify that.
You heard me correctly.
So I've clarified.
Thank you. Counsel, you may proceed.
Thank you.
Before,
Sorry, I didn't. Sorry about it.
before you proceed, Advocate Batohi, at the time when this meeting was held, you were just a month in the office. And you say you wanted to have an objective view of what is happening. Don't you find it peculiar or inappropriate that instead of having a meeting with your prosecutorial team that would give you the facts from the NPA's point of view, you then hold a meeting with an SC, and there is nothing wrong with that, but together with the team, with the opposing team, did you, and at that time, and even maybe sometime in future, as you rely on the fact that you're not forced or you're not expected to read the entirety of the docket. So at that time, you had not read, you had not formed your own opinion, but you are now meeting with this SC and the opposing counsel. Would that really give you an objective view of the matters that you are discussing?
I didn't say that the meeting will give me an objective view of the matters we were discussing. I said the meeting was more to discuss, to hear what they had to say, but there was not going to be any decisions around it. The objective view that I was talking about is the view that I got after I appointed the panel chaired by Advocate de Kock with regard to the Boyson matter. That gave me the objective view in the matter.
What was the purpose of this meeting?
The purpose of this meeting, and I'm again trying to, you will recall I couldn't even remember this meeting when I was asked earlier on. So I'm finding it very difficult, but I'm basing it now on what we have before us as some record of that meeting. It appears that, and again, I'm actually wary to speculate about it because then I'm held to it as being the purpose of it when I couldn't even remember the meeting. So from what we have before us, it appears that counsels were talking, Advocate Epstein and counsel for Mr. Boyson, Epstein acting for the NPA, and they wanted to meet with me for some reason and put some proposals. And I was prepared to listen with my counsel in the context of the review proceedings. So I can only assume on the basis of what we had was that that was the context of the meeting.
Thank you.
Okay, but Ngcukaitobi is 10 to 5. I don't know whether you want to pause here or you want to proceed with regard to these questions that we have been dealing with so that you don't start a new matter
Yes.
and leave it hanging.
Yes. Madam Chair, let me proceed on this particular theme.
Yes, thank you.
Advocate Batohi, there is a simpler reason why you did not invite the prosecution team. And it's clear from the minutes themselves. That team was at that point led by Advocate Mayema. Is that not correct?
That's correct.
You already entertained the prospect that Advocate Mayema would be subjected to discipline. I asked you about that right now. Correct?
As I said, I had not made any decision around that, but given what was in the public space, I needed to carefully consider the matter and then decide. But what was in the public space did not look good. But I still needed to base any decision that I make on evidence.
Yes.
And I should also say that the decision to hold disciplinary proceedings against all of the, besides Advocate Chauke now, because I see this as a disciplinary proceeding, all of the other accused, sorry, I beg your pardon, all of the other staff members, advocates, was not taken by me. That decision, that's a labor process that requires the appointment of an investigator to investigate the matter and present evidence before a chairperson. I had nothing to do with that decision to institute disciplinary proceedings. There's a labor process that I'm not involved in.
If you could just keep your answers to my question, they can be long, but they must answer the question. I thought it was common cause because you are the one who introduced the concept of discipline. And I asked you which employees fell within that bracket. You mentioned Advocate Mayema. Is that not correct?
I did.
Yes. Now, you also stated that the colleagues that were part and parcel of the PCLU would be disbanded and sent back to their respective offices, which included Advocate Mayema. Is that not correct?
That's correct.
Yes. Now, that seems to be the most logical explanation why you did not invite Advocate Mayema to this meeting. it is because of your own bias against him.
May I answer that question?
Yes.
In order to answer that, I must reiterate what I said earlier. I did not take any decision to institute disciplinary proceedings against any of the other advocates in this matter. I didn't even in this matter. I made a referral to the president. So any suggestion that this is because of any bias against anyone is completely untrue, because that decision was not taken by me. There's a completely separate labor process that unfolds. And so I want to completely dispel any suggestion that because of my bias, they have been disciplined. That is certainly not the case. I had nothing to do with that decision.
Again, you're not answering the question. Because of your bias, they were not invited to the meeting. You already had a prejudiced view against them.
I didn't see the need for them to be at that meeting. I wasn't sure at that point whether they had in fact applied their minds properly. You may call it a prejudiced decision or prejudiced view, but I wanted to take an objective decision in this matter by anyone. And I therefore got an independent, objective team to look at the evidence afresh.
Yes. You've been referring to the opinion of Mr. Epstein SC that before a poker certificate is signed by an NDPP, it is not required for that decision to be rational, that each and every scrap of paper must be read by the NDPP. Is that correct?
There's two things you said. You said it is not required that it be rational.
That for it to be rational.
Oh, can you repeat your sentence, please?
You have been referring to the opinion of Mr. Epstein SC that says it is not required for the decision to sign a poker certificate to be rational.
One moment, please, because I got to answer this properly.
Yes, that the NDPP...
It is not required?
Yes, for the decision to be rational, that the NDPP must read each and every scrap of paper that is contained in the docket. You remember that? You referred us to the memorandum given to you by Advocate Epstein.
I did refer to the memorandum. I'm not sure whether it addressed the issue of rationality. It certainly said that it's not expected of an NDPP to look at all the details in the dockets. I'm paraphrasing. I need to look at it again to see
I understand,
precisely what he says.
but you answered that question in order to defend yourself why you did not read the dockets implicating Major General Boyson. That is why you referred us to that paragraph. Is that correct?
I didn't refer it to defend myself. I referred to it to explain what is expected of a reasonable national director in the circumstances.
Yes, but I thought it was a response to my question when I put to you that when Advocate Katz said there was nothing in the dockets, it was incumbent upon you to verify if that statement was accurate or false. Then you referred us to this passage. Hence, I'm saying it was you defending yourself against an accusation from me that you should have read the dockets to answer Mr. Katz.
With all due respect, I was not defending anything. I was simply stating what is expected of a reasonable national director in the circumstances.
Now, the problem I have with that formulation is that the question in this case is you referring Advocate Chauke to a misconduct inquiry on the basis that he took decisions without evidence, but you never having satisfied yourself whether there was indeed no evidence by looking at the docket.
Can you repeat that, please?
At some point, Advocate Batohi, you'll have to ask us to stop repeating ourselves unless you are doing it on purpose. And I've been noticing it's a trend.
Chairperson, if
And
I may.
don't play victim, please.
Chairperson, if I may, I'm not playing victim. That is most unfair. I am trying, Chairperson, to write down so that I properly answer the questions. I think I should be given that opportunity.
Repeat the question, Council.
Thank you. The question in this case is whether or not you were entitled to refer Advocate Chauke to a misconduct inquiry on the basis that he took decisions to prosecute or recommended decisions to prosecute or supported decisions to prosecute, all of them, without evidence, when you did not read the dockets to confirm whether there was or there was no evidence. Do you accept that that is the question in this case?
It is one of the questions in this case.
It's the central question. This case has nothing to do with whether a poker certificate should have been signed by the NDPP. This case is about whether the NDPP can refer a misconduct inquiry to the president about whether the DPP has taken certain actions without evidence when the NDPP knows nothing about the docket.
Chairperson, I'm finding it very difficult to respond because these are very important questions and I have to carefully consider them before I respond. So I would appreciate it if it's slower so I'm able to write it down and properly respond.
Thank you. I will be slower. Let me
pause in between, please.
Let me break them down. Number one, we have established that you never read the dockets, correct?
That is correct.
Number two, we have established that you referred a misconduct inquiry to the president, to the minister, to be referred to the president, correct?
That's correct.
Number three, we have established that the central issue to be decided in that misconduct inquiry is whether or not the decisions that were taken, allegedly taken by Mr. Chauke, were taken with or without evidence, correct?
So to answer that, Council characterizes that as the central issue. My response to that is that it is one of the issues before this court. Whether it's central or not, I can't comment on that, but it's certainly one of the issues before this inquiry.
But Advocate Batohi, the problem is 3.1.1.1 right up to 3.1.1.5 speak about no evidence. It is the golden thread that combines all of the charges.
It is one of the important aspects of this matter.
Yes. Now, this is why I'm putting to you that these cases you've been referring us to are irrelevant to your decision to refer a misconduct inquiry about absence of evidence when you have no clue about the dockets.
These cases are irrelevant to my decision to refer the matter when I have no... Can you please complete the last one?
Well, you have no clue about the contents of the dockets because you never read them.
So, Chairperson, what is required of a national director when he or she refers a matter to the president is that you must have reasonable basis to refer a matter to the president. in this particular case, in my view, having considered all of that which was before me, I formed the opinion that there was a reasonable basis to refer this matter to the president. And in my view, it was not necessary for me to simply read to read the dockets itself to form that reasonable basis. I took a lot of effort in trying to ensure that I got the decision right and that I had reasonable basis to do that. There were opinions, not just one, and that was simply because I wanted, referring a matter to a president, in my view, is a very serious matter that I don't take lightly. And so I don't agree with the proposition by Advocate Ngcukaitobi.
See, Advocate Batohi, it's precisely because asking the president to convene an inquiry like this is serious business, that you have a duty to satisfy yourself that the charges are sustainable. The only way you could have done that is by reading the dockets to see whether it is true or not that there was no evidence.
I disagree that this is the only way I could have done this to satisfy myself that there was a reasonable basis to refer the matter to the president.
And your failure to read the docket before making the referral to the president shows you either as vindictive against Advocate Chauke or as grossly negligent in your job.
I have nothing against Advocate Chauke. Absolutely nothing. He's in fact a good advocate. But my decision to refer is not about whether Advocate Chauke is a good advocate or not. It's about what is the evidence that you have before you that allows a national director to come to the reasonable conclusion that this matter must be referred to the president. And in my view, to refer a matter simply because I'm vindictive, I mean, there should be an inquiry into my fitness to hold office. This is just...
Well, I didn't say that.
It would be unacceptable for a national director to refer a matter to a president without any evidence, without coming to a conclusion that there is a reasonable basis to do that, but simply because you are vindictive. That is certainly unacceptable conduct on the part of any national director, and I would never do that. As far as gross negligence is concerned, in my view, I was anything but grossly negligent. I ensured that I appointed a panel to look into the matter in the first instance. Thereafter, I obtained several opinions. I may not have read the evidence in the dockets relating to the racketeering charge, but what I did do is I read all of the opinions, in particular Dr. Broughton's opinion that had evidence in terms of documentary evidence attached to it, and satisfied myself that there was a reasonable basis to refer the matter. I am not judging. I came to the conclusion that there's a reasonable basis, and it's for this inquiry to decide what the outcome should be after this investigation.
Can we just conclude then that minute? And I want to refer you to page 344. Now, you remember that
Just a moment.
344 of file 3.
I'm there.
You remember that on Monday, I put it to you that the information I had was that Mr. Sebela Metsa was already instructed on that day to take steps to withdraw the opposition. You remember that?
I don't recall that.
All right. Well, I put it to you on Monday, and you said you didn't have any recollection. Now, at page 344, Mr. Carl van der Merwe says, Joseph, that is Mr. Joseph Sebela Metsa, and I need to see the JP and say, don't put the case down immediately. Give us time. We are not going to set it down. Now, the JP that's referenced there was
Sorry,
Judge,
where are you referring to?
page 344, the first line.
Yes, I see that.
So when he says Joseph and I, he means Mr. Sebela Metsa and I will need to see the JP and say, don't put the case down immediately. Give us time. We are not going to set it down. The JP reference there is the JP of KZN, Judge Japi. Do you know that? Or Yapi?
I know Judge Japi, and he was the JP.
But that is the JP they were talking about.
I don't know. If he was the JP at the time, then it's...
And look at how the meeting is concluded.
Mhm.
Mr. Katz then says, may I suggest that we adjourn today's meeting until a particular date so that the JP can be advised, and then at a date we can trash out a consent order. If I can play it forward, if you find something in terms of the predicates, we would need to continue, get dates, etc. But if you decide that the poker charges would not be proceeded, then other people may want to review people, but the court order may protect you. You could frame the court order however you like. I'm not fussed about that. You could massage the message about Jiba and Abrahams. There are two things that strike me there. The first one is that he has already told you and everyone in that meeting that the JP must be told that the parties are negotiating a consent order. No one contradicted him on that. Do you have any comment on that?
Yes, I do. There was absolutely no consent order that was going to be dealt with at that point in time.
I'm saying that in the minute, there was no one who contradicted him.
That may have been the case because it, I can't dictate to what Council Katz would say in a meeting. But what I can say is, firstly, he says, if you look at Joseph and I need to see the JP, don't put the case down immediately, give us time, we are not going to set it down. My understanding of that is there was absolutely no decision. In fact, if you look at 343 at the bottom, I say I'm going to get 3 people to look at everything, the racketeering charges and the predicate offenses, after I get advice to say we will run with it or decide how we are going to deal with the racketeering decision or proceed on the predicate. Again, here, I'm not saying it's exactly the words that I used. It's a matter of time frame. There's a lot of reading. I want to give it enough time, maybe a month, etc., etc. So it was on that basis, the fact that I was going to get a panel to look at this matter, that it appears that they were going to say, look, let's wait. Let's not set the matter down. But what Advocate Katz is talking about, a consent order, there was definitely no consent order that I had agreed to or that I was even envisaging at that time. So
Advocate Batohi,
that's all I can say about that.
No, that's not enough, because you've referred me to something that was said before, and I already told you that I'm telling you how the meeting was concluded. And I put it to you that he is saying, let's tell the JP, the matter must not be set down because the parties are trashing out a consent order. He is not contradicted on that position.
I want to disagree with that
Where is he
vehemently.
contradicted?
Vehemently, because sometimes context is everything. If you look at the paragraph, we can't ignore what was said just before that. The fact that I'm going to get 3 people to look into this, in fact, I got 4 eventually, and to then decide what to do. So the fact that he talks about a consent order there was never, ever any agreement that there was going to be any consent order. At that point, my decision was I'm going to get somebody to look at this matter and then decide what to do after that. I couldn't take a decision on a consent order at that time because I didn't know this matter. I didn't understand it. I needed to have the necessary information before me to make a very considered and informed decision, which I decided to do as per the bottom of paragraph 343.
Not only that, it goes further to say the court order may protect you. You could frame the court order however you like. I'm not fussed about that. And then you say something extraordinary. You could massage the message about Jiba and Abrahams. What message needed to be massaged about Advocate Jiba and Advocate Abrahams?
I have no idea.
Well, can I tell you, it's precisely the same message you made when you said that they had no credibility.
I have no idea what this is about. And if Advocate Katz says I could massage it, those are his words. I have no idea what he's talking about.
And again, you do not contradict him and say, sorry, Mr. Katz, there is no message to be massaged. These are my colleagues. I have respect for them.
The fact that someone doesn't say anything, it doesn't mean that, I mean, sometimes I just listen. I don't think it's necessary to speak for the sake of speaking. Sometimes you just listen and if something requires a response, you respond. Otherwise, you just ignore it.
Well, the problem here, Advocate Batohi, is that he is going along with your earlier statement that these 2 colleagues are people of no credibility. It's not as if you are ignoring something you disagree with. All of you agree on this.
I don't know what he's talking about here. I have no idea. I don't know what he's talking about when he says the court order may protect you. I don't know what protection I needed and why he would say that. I was going to get a panel to look into this matter. So I cannot explain why he said those things or what he meant by them. But from my perspective, I wanted to do things properly.
Now, earlier on, I put it to you that your intention was that the contents of this meeting must never be known, except by those people who were at that meeting. You remember that?
You did put that to me?
Yes. That is clear at page 346 in the 2nd line and in the 3rd line, where you say, I would prefer it that none of this gets out. And Advocate Epstein SC responds to support you and says, can I suggest this? Even that other people are being brought in, people other than those in the meeting. The only thing to be said is that an approach has been made to the NDPP and she is considering it. So that includes colleagues in the NPA, colleagues who are part of the prosecution team. All of those are classified as other people being brought in. It seems to me that your intention was always that this would remain a secret known only to the attendees of that meeting.
Absolutely not. And I want to explain that. Again, as I did earlier when I was asked that question, I explained this appears to have been, and again, Chairperson, I'm basing it on what I have in front of me. At the bottom of page 345, we talk about the media. This was a highly publicized case. Things get out into the public and the media makes a meal of it, which I've said. And then Carl van der Merwe says, I can advise the committee that this is not going to get out there, because I was concerned that him, Boyson and his team would say something about the fact that we had spoken. And I did not want it to get, it was not a secret meeting. I didn't want it to get out into the media, and then we get all kinds of media queries, etc. about it, given the high profile nature of this matter. And therefore, I would have said, I prefer that none of it gets out. Advocate Epstein, he suggests something, even other people being brought in. I'm not sure what he means by that, because that sentence is incomplete. The only thing to be said is that an approach has been made to the NDPP and she's considering it. And from the context, that seems to me to be that if it does get out to the media and I have to respond, then I can simply say that yes, an approach has been made and she's considering it. So this was never meant to be the kind of secret meeting that Advocate Ngcukaitobi puts to me. It was merely that, how do we manage it if the media gets to hear about this meeting? But it was never secret, it was never intended to be secret, and it was never meant to be kept away from anyone else in the NPA.
Can I ask you then, finally, on this topic, to explain why you withheld all of this information from this panel until Monday?
I did not withhold anything from this panel. Even when you asked me about it, Council, I said you are welcome to speak to Mr. Epstein and he can give you whatever he wants, because I'm not going to raise privilege or anything like that, because this is an inquiry and I want to be as transparent as possible. So to answer your question, I did not withhold anything. I could not even remember when you asked me about the meeting with Boyson and his team, well, not Boyson, with counsel for him. I couldn't even recall that we'd had this meeting. And so there's no intention to withhold anything. That's all I can say. And if we had perhaps found the, through a search, the emails from Mr. Epstein, we would have been in a better position. But there was no intention to withhold anything, because there's nothing secret about this. There's nothing wrong with it. Yeah, that's my response.
Well, if you are saying that there was no intentional withholding, why was it not disclosed? I just don't understand that. You've disclosed information all the way from 2019 and you've kept this out.
I didn't even know it existed. So I didn't keep out anything deliberately. That was why it wasn't disclosed.
Thank you, Madam Chair, for today.
Thank you, Council. Just 2 matters, just for my clarity. Page 336, Advocate Batohi. The 4th block, where you spoke about discipline. But my question relates to the acronym there, PCLA, and your answer was it is incorrect. It should read PCLU. What is PCLA?
PCLU.
No, what is PCLA?
I don't know what is PCLA.
What is PCLU?
PCLU is the Priority Crimes Litigation Unit in the NPA.
Page 343. Advocate has talking there, and he's referring to the 5 predicates. I suppose that referred. I beg your pardon. I beg your pardon. Page 343, the 3rd block, reference to 5 predicates. Am I correct that he was referring to the 5 predicates offenses of the 7 in relation to Advocate Major General Boyson.
Chairperson, I'm not sure whether he was referring to the 7, but he says the 5 predicates and then he says the Howick events. So it seems like he's referring to the events that took place at that scene. But I can't say that he's referring to the 7th. He will have to.
Or any of the 7?
Chairperson, I'm not which 7 predicate offenses Chairperson's referring to.
I'm just thinking that as Advocate Ngcukaitobi alerted us, the charges, the racketeering in relation to, I'm saying racketeering, with a view that that could be inclusive of predicate offenses against Advocate, Major General Boysons were 7. And please correct me if I'm getting that incorrectly. And my question is based on that because I see there, Advocate Katz says that he's referring to the dockets, that there was nothing to pin the 5 predicates, supposedly against Major General Boysons.
I would assume that, Chairperson.
Is that your assumption also?
I assume that it is against him. That's correct, because, yes.
And I know that the question may be unfair to you, but do you have a sense of what those 5 predicates offenses could have been?
Chairperson,
that he says there was nothing to pin on them.
Chairperson, it's difficult to answer what he was thinking. But my recollection of the panel report is that there was no evidence. You required 2 predicate offenses in respect of poker, at least 2 predicate offenses to be proven. And the report was that this requirement was not satisfied. So I'm not sure when he means 5 predicates, what exactly he's referring to.
And in relation to 344, the conclusion that was raised, or what appears to have been the conclusion regarding the consent order that was to be presented to the JP. Advocate Katz is talking there, and later, Advocate Epstein says to him, Alton, pardon, at page 344, it's a long day for all of us. After mention was made of a court order and what ought to have been presented to the JP, below that, Advocate Epstein with someone else is saying, we just need a court order to set aside those mechanics won't be difficult. You see that?
I see that.
And then you make a remark below that. I'm not sure it will be difficult or easy if there is a court order. And Advocate Katz says it's not just not entering a position, but withdrawal is more.
I beg your pardon, Chairperson, the last part?
If you read just below you there,
Yes.
after your remark, it says withdrawal is more. I suppose he means what he's saying, that the court has a discretion. You see that?
Chairperson, I really don't know what he means, whether it's accurately captured. Doesn't make sense to me. Well, I can't explain it, Chairperson.
Yes, but
What it means.
I want to go back to your remark. I'm not sure it will be difficult. What were you referring to there?
Well, again, Chairperson, we're trying to make sense of this record. It appears that Advocate Epstein says before that, Anton, we just need a court order to set aside. Those mechanics won't be difficult. So I respond, I don't know if it will be difficult or easy. I don't know. So I'm not sure what I was trying to convey at that point. I would like to say, Chairperson,
You are saying you don't know if those mechanics will be difficult or easy if there is a court order. Do you understand you to mean that?
Chairperson,
as it appears there?
Chairperson, it appears that I'm saying I don't know it will be easy or difficult, but it's certainly not a conclusion that there will be a court order. And that was, in my view, Chairperson, if we look at page 345, I say,
Let's go about 344. I just want to understand your latter phrases. If there is a court order, in other words, if my reading is correct, I'm not sure whether those mechanics will be difficult or easy if there is a court order.
yes, I don't know what the context was, but for me, I didn't understand. And as far as I'm concerned, it would have not even been an issue because there was not going to be a consent order, certainly in my mind at that point.
Yes, thank you, Council.
Madam Chair, I think this may be a convenient time. I'll start on a new topic tomorrow morning.
Indeed, it is a convenient time to adjourn. Advocate Batohi, we will adjourn now and reconvene at 9 o'clock tomorrow morning. Thank you.
Noted, Chairperson.
We adjourn.